Morning, everyone. Welcome to our one and only day of our November case call. My name is Christina Garrett. Sitting with me today are my colleagues, Judge Seema Patel of the 2nd District and Judge Christopher Yates of the 3rd District. We welcome you. We know that these cases are very important to the litigants and their counsel. We can assure you that we've been diligently working on these matters that we're hearing today, and we have had the benefit of your excellent briefing. Today, we have several cases. I'm going to give you some basic ground rules. Each party will be allotted 30 minutes aside if you are opposed. If you are unopposed, you will be allotted 15 minutes. If there are more than one attorney on one side, please let me know how you intend to divide your time at the outset. And also for the appellant, please let me know at the beginning if you would like me to reserve time for rebuttal. We are familiar with the relevant facts and pertinent case law involved with each of your cases. So I do please recommend that you focus your time on your more salient issues. And lastly, if your case involves children, issues involving sexual assault or other sensitive topics, please do not mention the parties' names. Instead, please refer to them by initials or other private identifiers. This is a recorded public hearing that will be posted on YouTube today. And with that, we will call our first item on the docket, calling case 367-951, People of Michigan versus Michael Green.
Good morning, and may it please the court, Jonathan Simon, on behalf of Mr. Green. I know the court is familiar with the arguments, and I would stand on my brief. And if there's any questions, perhaps attempt to answer them.
I just have one question. If you're right on the sufficiency of the evidence, the CSC2 convictions still stand and the sentences are unassailable, right?
That's correct. The issue is whether there was penetration.
Right. That's all I have.
All right. Thank you.
Thank you so much.
Thank you so much.
It's great to see you. Take care. That matter will be submitted. Calling item 2, 368-763, People of Michigan versus David Richard Kaman.
Good morning, may it please this honorable court. Alexandria Taylor appearing on behalf of the appellant. We're here this morning on behalf of David Kaman. We have few salient issues. One, the declaration of witness MM is unavailable, seriously undermined the trial. We read in the people's response that saying that she had a physical infirmity, but anxiety and merely not wanting to testify is insufficient to satisfy this court's burden.
Can I ask you a question about that? Because the trial court made findings that MM was physically shaking and distraught. And it wasn't just the announcement that there were all sorts of stressors. There was a clear physical manifestation that MM was really in terrible shape. Don't we have to defer to the trial court's findings on that?
Well, Your Honor, what I would say is MM testified during the preliminary examination, and then there was an incident, and then she came back, or he came back and testified. And so it ties into one of our other issues, Your Honor, which is the proof of incarceration. And so that is one of the issues that my client brings up under the ineffective and under his claims. So that proof of incarceration was produced within a week of the trial. And so our contention is that MM simply did not want to testify because, as Your Honor knows, during the preliminary examination, which we mentioned in our brief, there was presentation of another incident, which MM had alleged, which MM consequently withdrew, and that one was dismissed.
Yep.
And so that ties into our contention that MM knew, because the proof of incarceration was presented that stated, you know, these specific dates where MM testified, it's happened between these dates, you know? And so MM knew that this was going to be presented. And so our contention is that this was just a mere unwillingness to testify because, again, during the preliminary examination, there was some anxiety. I believe there was testimony about a seizure. MM went to the hospital and then came back and completed the testimony. So what was different here? What was different, Your Honor, is the fact that that proof of incarceration was presented from MDOC, unequivocally showing that between these dates, Mr. Kaman was incarcerated. He was in the Michigan Department of Corrections.
Counsel, didn't MM start exhibiting the same symptoms at the second preliminary examination date?
Your Honor, they characterize it kind of as a seizure, so I didn't represent him then, so I don't want to misstate anything. So I don't know if it was the exact same symptoms, but maybe some anxiety. But again, I believe there was mention of a seizure.
Okay, because I thought MM nearly passed out on the second date also. But
Right,
Yeah,
yeah,
okay.
there was something, they said a seizure, an ambulance came, but then that to me is the most important part is MM came back, so there was these physical manifestations, but it came back and MM completed the testimony.
And just to be clear, you're not challenging the CSC4 conviction, right?
Well, I mean, they're intertwined because the trial was consolidated. So if this court were to vacate, I mean, it would only follow that it would be vacated on that one as well because it's the exact same testimony. Yeah.
Okay, I got it.
Yes.
I
Thank
was
you.
a little unclear on that, but I got it now. Thank you.
Thank you. So this wasn't unavailability. It was an unwillingness once the perjury risk appeared. And the state never met the burden of showing that the medical unavailability by competent proofs. That was never shown. And it also ties in, it's so critical because it ties into the other issue is that the people, they want it both ways. So you want to say, okay, she was medically unavailable. There were proofs present. But then at the same time, say that my client's right to confront wasn't violated. But here's a salient issue. So at the preliminary examination, and I believe it was the people who elicited that testimony as far as a date range, it's like, are you sure it's this, this range? Yes, I'm sure. Well, the problem then comes in is that when MM doesn't testify at trial, the people can't then argue that, okay, maybe the dates were wrong, because then that would have had to been a trial issue. And then that would have been for the trier of fact to say, okay, maybe she did have the dates wrong, but that never happened because MM didn't testify at trial.
Counsel, sorry to interrupt you, but
Yes.
to my recollection, she didn't file the claim of appeal in the CSC4 case, though. Her claim of appeal only had the CSC3 lower court docket number.
Yes.
Okay.
Yes, Your Honor. The other evidence that we put forth here today, as I've stated multiple times, is with the proof of incarceration, the MDOC letter. Part of that ties into my client's ineffective assistance of counsel claim, because again, that was something that he had been pushing forth all along because he knew, obviously, since the preliminary exam, like, hey, these are the dates that she's testifying to. I was incarcerated. And so this will be the best evidence in my defense to prove that I'm innocent is I was incarcerated. And again, that evidence was not produced until merely a week before trial. And so this can't be chalked up as to some strategy. I mean, this was an omission, potentially depriving the jury of context. And even when it was presented, there were 5 pages. The first page was a cover letter from the MDOC with the letterhead. It was very official looking, but the actual document that was submitted as a defense exhibit was only 1 page. And it could have been interpreted as something that somebody drafted on in a Word doc and made into a PDF. It wasn't the official document that was presented pursuant to the subpoena. The other thing that we present is the prosecutorial error, the improper impeachment. And so I know I saw in Madam Prosecutor her response and saying, okay, this was handled by the jury instruction, which is the same standard jury instruction in every criminal trial, like lawyer statements are not evidence. But the reality is that's a bell that you cannot unring. Once these things are out, it plants a seed, and there was no curative instruction. So I think that's the important distinction. It was just a normal jury instruction. And so even though the court sustained the objection, again, the jury heard it. And this was also an issue that I argued before this honorable court back in 2019 in People versus Amanda Hardy. Although it's unpublished, it's November 26, 2019, docket number 339236. It was a very similar issue of prosecutorial error in things that are said to a jury. And what this court said then is that the test for prosecutorial misconduct is whether the defendant was denied a fair and impartial trial. And so, this court stated, it's well established a prosecutor may not convey a message to the jury that the prosecutor has some special knowledge or facts indicating the witness's truthfulness. And just like in the Hardy case, this honorable court recognized that it boiled down to witness credibility. And in fact, Madam Prosecutor said that in her response, like this really boiled down to MM's testimony. So it's no different than that. And so even though this objection was sustained, that planted a seed in the prosecutor even prior to trial. It was well established that nothing from that Dorchester event was to come in, and everyone was well aware of that. But still, the prosecutor planted that seed when those questions were elicited on the stand, and there's nothing you could do to unring the bell, and there was no curative.
Isn't there some argument to be made that the decision not to ask for a curative instruction could have been a strategic decision? Because if there's a question asked, objection sustained, at that point, you could either leave it alone or you can ask for a curative instruction. And if you decide to leave it alone, it de-emphasizes the problem.
Yeah, well, Your Honor, I'm just going to defer to what this court said in my Hardy case. And like I said, that I argued, it said that defense counsel, talked about the timely objection, which it was myself that made that. And the court overruled the objection and failed to immediately give a curative instruction.
Right.
So going by like this court's rationale in this case saying, okay, possibly it may have been different had the court immediately gave a timely instruction. So using that same rationale, I would say that no, it wouldn't have been harmful. Like an immediate curative instruction is a signal to the jury like, hey, this was improper, and this is not something that you should consider. But because that wasn't done, again, as in the other case that I had where this court vacated that conviction, it's the same line of reasoning here. It can't stand.
Thank you.
And so the other argument that my client brings up is a misleading DNA/sane evidence. There was a commingling of evidence from the dismissed Dorchester event. And I do realize that trial counsel stipulated to the DNA our argument that was ineffective because the confusion was prejudicial. The confusion was prejudicial here. And so I know that was something that was partly used in the closing argument. But again, that wasn't strategy. That was prejudicial to his case, taking the totality of the circumstances. And so that's leading into just the ineffective.
But the DNA evidence was inconclusive, right? I
Right.
mean, so in your view, because it was inconclusive, it shouldn't have come in at all?
It shouldn't have come in at all. It was confusing because then you had these mentions of the other DNA from the Dorchester event. And so it just was confusing in totality. And that leads, Your Honor, into my ineffective assistance of counsel claim, just a failure to object.
So 4 minutes, just so you know.
Okay, thank you. I'm trying to go
fast.
fast. My ineffective assistance of counsel claim, the failure to object, explain, or request limited instructions. And so this case here, Your Honors, isn't about guessing a jury. It's about giving a new jury the truth that the last one was denied. And so we thank you so much for your time today on behalf of my client. Thank you.
Thank you. Thank you. All right, that matter will be submitted. Calling item number 3-369924, People of Michigan versus Heather Nicole Alexander.
Good morning, Your Honors. Roma Tishkevich on behalf of Ms. Alexander, who's in the courtroom today behind me. Your Honor, Ms. Alexander's case was for the jury to consider two separate counts of animal cruelty. The first count was adequate care regarding food, shelter of more than 25 dogs, Chihuahuas, and that's a 7-year felony. The second alternative count was adequate care or caging of more than 10, but less than 25 animals. That's a 4-year felony. They're two separate counts. And this case was a close case for animal cruelty, as the evidence showed. We had 2 veterinarians testify. The animals were in good health. They had veterinarian care. They were well fed, watered. They were taken out every day from the van. The conviction seemed to stem from that we had 27 Chihuahuas or 26 Chihuahuas and 1 Sheltie in a van. And so after the veterinarians gave their testimony, the prosecutor was worried and they did an alternative count. They're saying, well, maybe less than 25, there'll be a caging issue with Chihuahuas. That there was one cage with 9 male Chihuahuas, but there's another cage with a mother and her puppies, which was an appropriate caging situation. So the testimony was that if they stayed in the van for a prolonged period of time, because when they were removed from the van, they were in good health. There's no dispute they were in good health. But if they stayed there for a prolonged period of time, then they might, their health might not be good. So in Miss Alexander's case, the jury never properly considered the alternative count, the elements for the alternative count.
I don't understand why this is such a concern to you, because it seems to me the jury solved the problem. Count 2, the added count, was just treated as an alternative count, and the verdict form says proceed to the alternative count only if you find defendant not guilty of count 1. They found defendant guilty of count 1, which was the original charge and the information. They didn't do anything with this alternative count. And I'll agree that the way the alternative count was presented and framed in the verdict form and everything is baffling, but it never really became anything of consequence, did it?
I think it did. I think the whole theory of Miss Alexander's case and that once the vets testified that there was a problem with the freedom of movement, the prosecutor worried, and they said, "All right, we got to pare this down because we might be in trouble because we might not show that all more than 25 animals had problems with movement."
But the jury found beyond a reasonable doubt that that actually did happen. That's the one and only charge they convicted on, right?
Yeah, yes, Your Honor, they found her guilty of count 1. But that goes to our second issue about the sufficiency of evidence, right? Could they have found her guilty of count 1 when they're saying more than 25 animals had problems with movement, when we had cages that were appropriate, less than 25? We could not show that there were more than 25 animals.
But we've seen the pictures, the videos in the record, and to me, it does look like a problem, but it doesn't matter what I think. I mean, the question is whether a reasonable juror could find guilt beyond a reasonable doubt. I don't know how you can look at those pictures and say that no rational juror could find guilt beyond a reasonable doubt.
But then Your Honor, you have to look at the evidence. You have to look at the veterinarians testifying, saying that the animals are fine. They were in good health. They had vets checking on them. They were well fed. So you have to look at that. And when it's a shocking, and for anyone, when they see pictures of 9 Chihuahuas in a cage, they're shocked. But then you don't see a picture with a mother and her puppies in a cage, right? And they're saying, well, that's appropriate. So we're looking at 25, more than 25 animals were abused for the jury to convict. The alternative count was less than 25. And the jury never received that instruction. They never considered if it was less than 25 animals that had problem with movement. The more than 25 was adequate care. The less than 25 was the caging. And so, and then as the court pointed out, the verdict form was the exact same verdict form. It would be like, count 1 homicide, count 2 homicide, or count 1 OWI and count 2 OWI. So the jury weren't instructed during the jury instructions, then they receive a verdict form that's identical.
It looks like a lesser included offense, and clearly it was.
Yeah, it is. And I made that argument. I was trying to get the prosecutor to make a position on that argument. They would not, if it's a lesser included offense. And the prosecutor in their brief indicates that we waived this issue, but we raised ineffective assistance of counsel in the trial court. We preserved it. And it's interesting, the Supreme Court last year in the Nelson case looked at the standards of review with ineffective assistance of counsel if you don't do anything. If the attorney doesn't object and an IAC claim is raised, the standard of review is less than is lucky if the attorney objected. So if the attorney objected and said, hey, the attorney said, Your Honor, it should be 25 or less, raised an objection under the Luckety standard, the standard of review is more than a preponderance of evidence, which is a problem. And the Supreme Court, we're hoping the Supreme Court would look at that in the Nelson case recently, and they kind of punted the issue. And maybe this is the case that we'll take a look at that issue. But so I think the prosecutor admitted, and this court, it was confusing to the jury. And it's important in this case because you're looking at, it's like a high BAC case, you know, it's over 0.17 or under 0.17. And you're looking for, is it over 25 that didn't have freedom of movement? Is it under 25? Which ones were not caged? So I think that's the problem in this case. So I'm more than happy to answer any questions.
Thank you so much for your argument today.
Thank you.
Have a
Thank
wonderful
you.
day. All right, that matter will be submitted. Calling item number 4, 365-738, People of Michigan versus Kelly Nicole Braun.
Good morning, Your Honors. Kirsten Nunn from the State Appellate Defender's Office on behalf of Ms. Braun, and I would like to reserve. So I'm taking Judge Robinson's Garrett's point to heart. I am just going to focus on what I feel are the most salient points of in our argument and rely on briefing for the rest of the other issues. But I'm happy to answer questions, obviously, on any of the issues that any of you may have. The most salient points I believe in that we raised in our brief kind of speak to under the IACs that we filed. And the one we started with, which I think is probably the crux of this case, is the fact that trial counsel was made aware by Ms. Braun that she was, exhibiting, behaviors that I think do raise concerns of competency. Specifically, she told trial counsel that before trial and during trial, while it was ongoing, that she was hearing voices and getting signs from God through birds. He was aware of this, but nothing was ever, really done about that. And then most concerning, on the last day of trial, and I want to really clarify this point because the people also seem to be confused about the sequence of things of when this particular event happened. But on the last day of trial, after the jury rendered its verdict, which would have been February 23rd, I believe, Ms. Braun jumped into the St. Clair River. So there is yet another, I think, even more significant factor that called into concern her competency that she had already been expressing to her trial counsel throughout. But instead of
There's a substantial record about how lucid she was, isn't there? There was a repeated failed attempt to plead guilty where there's a regular colloquy between the court and her, and then she testified at trial, right?
she did testify at trial.
And that certainly seemed coherent.
She did testify at trial, and you are correct, Judge Yates, leading up into the days of trial, there were multiple days going back and forth where Ms. Braun expressed a desire to enter a plea and then rescinded that desire and so forth. So point taken. However, this court has recognized for years that, competency is an ongoing concern. And so someone might exhibit behaviors, or a court might even make a determination at one point in time that somebody is competent at one point in time or on one day, but that does not mean that competency determination goes on in perpetuity. Someone's mental capacity can deteriorate over time or over legal proceedings. And Ms. Braun was exhibiting these things over that course of that period. So point taken, yes, she did actually answer in the affirmative. She testified okay, but that does not negate the fact that she was still having these other issues and that she did express these to her trial counsel. And he did not do anything about it that he had a duty to do. Now, I do acknowledge that in her affidavit, she does say that he, made a request somewhat off the record, but I think that's akin to not making a request. If it's off the record, like we don't, know that that's something that was significant and should have been brought out in front of everyone to give the judge a determination to do that. As it relates to our, is not requesting a referral for criminal responsibility. I think that does speak to a diminished capacity type of defense, which we acknowledge in our brief. We realize that we are in carpeting land right now, so that is not something that he would have actually been able to do. However, it was raised in this brief to preserve that issue, and I'm glad that we did, especially in light of the fact that just last month our Supreme Court had hearings, an oral argument on People v. Madison, which is going to actually make a determination of whether People v. Carpenter was wrongly decided, which is obviously our position. So keeping that in mind, I think that is an issue that was worth bringing up to preserve, because again, the way that she was exhibiting herself to her trial attorney, I think there is a question of her competence throughout. And even as we go back to whenever the offense happened, but because there was no referral made for her to be evaluated, we have no basis to kind of go any further on that.
As I recall, the diminished capacity defense was actually raised not even as ineffective assistance of counsel, but as a direct claim, right? Was that in your brief or the standard 4 brief? It seems to me that
believe it's
that's
in it.
preserved, so she would get the benefit of the Supreme Court's decision, because I think obviously there's a very good chance they may say that diminished capacity is now a
I
viable
agree, it was
defense.
kind of between her standard for a brief and the issue we raised in here,
Yeah.
that was kind of,
Yeah, I thought you were covered adequately in case the
Thank you.
Supreme Court goes your way.
No, thank you. That is usually the hurdle that is overcome in those types of cases is the preservation hurdle.
Yep.
So that's what we were trying to, attempt to trying to address. Moving on to what I think is probably the next most salient point that was raised in the briefing here was that Officer Campbell, when he was on the stand, testified definitively that that was Mrs. Braun in the video. And this is problematic because that was the sole issue for the trier of fact to determine in this case. We had this video, we see a fire being started and we see a house being burning down, but we didn't know who the identification of that person in that video was that started the fire. Well, Officer Campbell pretty much, usurped the role of the jury to make that identification and basically told them, I'm going to tell you. I'm going to answer that question for you. It's Miss Braun, nothing to see here.
Very clear, like using his expertise in terms of identifying, but not to actually make out who that was.
The video was not of great quality, and to the people's point that he, being a lay witness, was giving his opinion, and it was needed for the assistance of the jury to be able to, I guess, come to this conclusion. But I would argue that just like Officer Campbell, the jury was also shown multiple other videos of Mrs. Braun that he also observed earlier in the day that were much clearer, that actually kind of gave a better, I guess you could say, depiction of what she actually looked like. So taking into account that the jury also viewed the same things that he did, I don't think they needed him to tell them that. They didn't need his assistance for that, even with this grainy video, to point out certain things. They had enough that it presented to them. They had the surveillance video of her on the porch. They had the surveillance, sorry, excuse me, the surveillance video of the altercation earlier in the day between her and the complainant. They had enough to be able to make their own independent identification, notwithstanding Officer Campbell's identification of her for her. I do believe that was, again, that was the sole issue for them to determine. That was 100% in the province of the jury. He took that away from them when he basically said, hey, I'm telling you who it is.
Is it true that Ms. Braun did admit that she was the person in the video wearing the pink shirt? I
She-
thought that I saw that.
She admitted, I'm sorry, I didn't know, I need water. Going on.
Oh, you want to take some water? Take a moment.
I think I might have cleared it.
Okay.
Thank you. Thank you. She did admit that she was a person in the pink shirt that jumped over, but she also simultaneously continuously denied that she was the one that actually was the person that actually started the fire. And that was kind of the identification he had. And, yes, he did point out there was somebody wearing a pink shirt, but there was someone wearing a black shirt. But I think the problem here and the most problematic part of the testimony is when it comes to who started the fire. Definitively, he's saying, that's her, that's Miss Braun, that, those are her actions. She's the person that you see that is actually the one that is the catalyst for this fire being started. And that is problematic because he is a police officer. It's not as if he was just one of the neighbors that got up and gave this kind of ID. He is a police officer. And as we all know, a police officer's testimony does carry a little bit more weight, whether he's testifying as a lay witness or expert witness. He's still a member of law enforcement. And when a jury hears something like that, especially in a case like this where we had, no DNA there was no DNA, no fingerprints. We just have this video, albeit a very grainy video. So we are trying to figure out who the identification of this person is. And we have law enforcement saying, I'm telling you who it is. There's, that's all you need to know.
We have a terrible time getting video when it's in the lower court record. And I wasn't able to watch the video. Is it in the record on appeal that's in front of us? Did somebody actually submit it? Because I apologize, I was not able to watch it.
Oh, it should have been. And to your point, it took me a lot of wrangling to be able to actually, be able to get it, but it was made a part of that. And I apologize that
Okay, no, it's not your fault. I'm not
but
blaming.
you had to,
Right.
it is hard to play it. And then I had to try different mediums as well to be
Yeah,
able to even
I'm not
play it.
blaming you at all for this. I mean, the difficulty we have is a lot of times there'll be a critical surveillance video and we try and try and try to get it. And for some reason, it is so difficult. And so if it's in the record,
It,
I want to take a look at it if I
no,
can.
it is, but I mean, I will double check, but
Okay.
maybe again, I say maybe
Thank
you
you.
can join us in that crusade. As appellate attorneys, we also have a difficult time trying to ascertain those types of meetings.
Thank you. Thank you. And I didn't mean to suggest for a moment that you had done anything wrong. It's just frustrating and it's not your fault at all.
No frustration shared. I would like to reserve the rest of my time for rebuttal and address whatever the people may have.
But you actually have more than enough time. Thank you. All right.
Good morning. May it please the court. Kaylin Wilson, Senior Assistant Prosecuting Attorney on behalf of the people of the state of Michigan, the plaintiff appellee in this case. First, Your Honors, I'd like to apologize. I do believe that there was some confusion in the brief as to the issue of when she jumped in the river. I believe the fact section articulates clearly that we stipulate that she jumps into the St. Clair River, which runs by our courthouse, immediately following the verdict when they're taking her back to the jail. But then some portions of the brief appear to argue that it occurred after the sentencing date, which is not correct. So I want to make sure that the record is very clear, and I apologize for that confusion from the brief. I don't, however, think that the fact that she jumped into the river, whether it was after the verdict or after the sentencing, is relevant because that's not information that would have been available to the attorney when he was making his decisions about whether to refer for competency or for criminal responsibility. It's not information that would have been available to the court when she was making she was making a decision whether she sua sponte needed to refer. So I don't think it's relevant, but I do want the facts to be clear. I think Judge Yates, you're correct. In the 10 days prior to trial, all of us, defense counsel, myself, the judge, saw this defendant more times than any other defendant we've ever seen. Because she was attempting to plea, we do make these exhaustive records 6 days before the trial, 9 days before the trial, the day before the trial. And then she testifies in the second day of trial. So I agree that competency is something that can change over the course of time. But here, there really isn't a time that we don't know that she's competent. We know the day before she's understanding things very well. We know the second day of trial when she testifies, she's understanding things very well. But when she testifies, she is referencing and controverting things that the fire investigator said and things that the victim said. And that was the first day of trial. So we can see from her trial testimony that she was fine the first day of trial, that she was following along with the strategy, that she was able to respond to those issues, and that her competency really was not an issue. Mr. Leckley did not make a request for a referral on the record because it was not objectively reasonable. There wasn't sufficient evidence that would have backed that request.
Do you concede that there was some discussion of this off the record?
Yes, Your Honor.
Okay.
Which leads me to my next point. Even if it was insufficient, even if it was an error of him, it's not outcome determinative. There's no way that Judge Lane would have referred her. Judge Lane was the one who had taken these attempts to plea and had this colloquy with her over and over and over. Even if he had requested referral for competency, she wouldn't have done it. It wouldn't have made any difference in this case.
While you're on that point, do you concede that the diminished capacity argument is preserved? That if the Supreme Court goes the other way, that she would be able to avail herself of that decision? I mean, you get the benefit of whatever comes out while you're on direct review.
Procedurally, absolutely. I can see
Okay,
that she would
that's
be,
right.
that's available to her.
Right.
Factually, however, I don't think there's a single fact that points to a diminished capacity
Sure.
at the time of the incident. I think the evidence shows that if there were any issues with her capacity at the time of the incident, it's caused by her overwhelming use of methamphetamine throughout that day and has nothing to do with any mental state or mental issues. Similarly, I have no concern about Officer Campbell's testimony. In this case, we're talking about over 5 hours worth of video from approximately a city block away. The earlier video is more clear as it's in the daytime, but the later video is after dark.
What's your understanding of the status of the video on appeal? Because it may be my failing, but I haven't seen it.
As the trial counsel, I'm standing in for the appellate counsel today. I can certainly hope that it's part of the record, but I can't promise you that it is. Officer Campbell behaved correctly under 701. He was a lay witness giving an opinion based on things that he observed that would assist the juror. The point here is not that he's more qualified to render an opinion because he's a police officer. The point is that he's more qualified to render an opinion because he has watched this video over and over and over and over and over in his investigation and in preparation for trial. I'd watched it probably half a dozen times, and I did not see that there's a person walking their dog on the sidewalk on the other side of the house from the camera. And that's the moment where the person decides to hop the fence instead of walking back towards the gate, which would have brought her right into contact with the people walking the dog. But then once Officer Campbell was in my office and pointed to it and said, no, she jumps the fence because these people are walking their dog, then I could see it very clearly in the video, but it's just not something that I had seen myself, even though I'd watched it multiple times. The point in allowing him to give this testimony was really to save time for the jury so that he could summarize what was happening, he could acclimate them, he could explain the physical location, he could explain the characteristics. And this was so well explored by Mr. Lepley on cross-examination. It was very clear, both from my direct and from the cross, that this was just his opinion. And I went out of my way to have him give the specific reasons that he was relying on so that like her hairstyle, like the rips in her jeans, so that the jury could understand that his opinion was based on these reasons and they could independently judge. Did they see the hairstyle in the video? Did they see the rips in the jeans on the video? Did they agree with the opinion testimony that he gave? I think this also certainly was not outcome determinative though. This is not a case about, we know this is arson and who lit the fire, right? This is a case about whether or not it was an intentional act or an accidental act. She's been saying that the whole time leading up to trial, right? That she threw down a cigarette. That's her testimony under oath, that she got the victim to hand her down a lit cigarette to light her cigarette. And then she had 2 cigarettes, which is important because we believe this is arson because there's 2 separate sets some distance away. But her testimony explains that she had 2 cigarettes, that she smoked one briefly and then she threw them both down. She admitted in cross-examination that she was the person in pink, that she climbed into the house on the ladder and changed into a pink shirt, that she is every woman in a pink shirt that was seen in all of the different video clips throughout the day. She is not saying that she wasn't there. She's not saying that she didn't throw a cigarette down. She's saying that it was accidental and not intentional. So nothing about Officer Campbell's testimony would have been outcome determinative or reversible error. Beyond that, I would answer questions or rely on our brief.
No questions. Just for both counsel, I did check. We still don't have that video in our system. So if it is here, I can check with our clerk's office. Just maybe there was a mistake in not uploading it, but just so you know, if not, then you'll get an opportunity to submit that to us if you like. Okay. All right. Thank you.
And I do appreciate you, Judge Garrett, for double checking that really quick. Really quick, just want to push back on 2 of the issues that was raised by Mr. Counsel here, as it relates to the fact that Ms. Brown, in those days leading up to trial and those multiple hearings where we were going back and forth about whether she was going to take a plea. Yes, she did appear to be, very much, competent to understand the proceedings and everything that was going on, same with her testimony at trial. So point taken, yes, I would agree that the judge and the people might not have been aware of her, underlying competency issues. They're only observing her in trial in the way that she's responding before them. However, her trial counsel, she expressed her issues to him, directly to him. So he knew, despite what she might have been testifying or appearing out in the open, he knew that she was having these issues with hearing voices from, God through birds. It was his duty to alert the court, to ask to make the request for the forensic referral, and then for the judge to kind of take it from there. But I mean, I'm not asserting that the judge should have just looked at her and sua sponte, should have ordered one. It was on him to make the request and then for the judge to go from there. However, if the judge was made aware, and it sounds like perhaps there might have been an off the record discussion regarding this, if the judge was made aware of that she was having these issues, then I do think at that point in time, it was incumbent on the judge at that point to then, make a referral for the competency and criminal responsibility referral. Secondly, as it relates to Officer Campbell, in the video, I just want to make it clear, we are not challenging or taking issue with Officer Campbell's testimony in its entirety. We realize that, him pointing out that there was someone walking a dog and that person was wearing ripped jeans or had, a ponytail. Those are not the things that we are actually challenging. We are specifically challenging his identification testimony as when he actually says her and refers to her as, Kelly or Ms. Braun by name and makes that identification. We're not asserting that, he shouldn't have been able to get up there and speak to the video, at all. The whole purpose or premise under People v. Fonby and People v. Perkins has to do with whether or not the testimony that is being provided by that law enforcement officer is invading the province of the jury. There are certain things that they can say, like I believe in Perkins, it was okay. This court held that it was okay for the officer to actually give his expertise opinion that person was concealing a weapon or hiding a weapon. Perfectly fine. Where he crossed the line was when he actually said, that is I can't believe her name, but that is, Kathy so-and-so, is when he gave the identification testimony. That is the issue. That is the issue that we are raising here. Nothing that he did, I guess, aside from watching 5 hours of video, I would submit that still doesn't make him or put him in a better position in the jury to be able to make that determination for themselves. But for those reasons, we would ask that this court grant a new trial or in the alternative grant remand for an evidentiary hearing.
Thank you, counsel. Thank you both. Great to see you. Have a great day. All right, that matter will be submitted. Calling item number 5, 367749, Honorable Surin LLC versus County of Wayne. Morning.
Good morning. May it please this honorable court, Carrie Boylan appearing on behalf of the appellant. Your honors, I would like to reserve 5 minutes for rebuttal.
All right, thank you.
Thank you. I do believe that this case should be returned to the lower court and the lower court reversed because the treasurer did not comply with either the General Property Tax Act or due process in this case. In this case, the treasurer has conflated the different sections of the General Property Tax Act to conclude that all the treasurer was required to do was look at the Register of Deeds, find the most recent deed, and send a notice to the address on that deed. But that's not the case at all.
That's not all that happened. I mean, somebody went out to the property, there was a physical viewing, they left the materials there. I mean, I think you may have an argument when it comes to the surplus proceeds issue, but I don't see any issue when it comes to the forfeiture itself.
There's quite a bit, and starting with the posting on the property.
Yeah.
And the treasurer argued, I went to the property and posted a notice. 2 things. Number 1, a copy of that notice was never provided in his brief in the lower court or in response to the FOIA request. The treasurer did submit a purported affidavit that said on such and such a date, we went to the house. We went to houses listed in the attachment and posted notice. But in that affidavit, there's nothing attached to it. So it doesn't mean that a visit was made to this house or not. The treasurer represented that that's what it was supposed to mean, but the list of addresses wasn't provided. Number 1. Number 2, If you look, if we had a copy of the notice and I had discovery and would have obtained it, discovery would have shown that that notice, just like every other notice that the treasurer has ever sent in this case, indicates if you are not the owner, disregard this notice. So the notices, in my experience in the counties, is the notice that's posted on the house is addressed to occupant. So the notice that's posted, if it was, and the content in discovery would have revealed, it would have told the occupant to disregard this notice. So therefore, that notice is a nullity. Furthermore, under Hollins versus the Detroit Police Department, if someone other than the owner is given notice of the forfeiture process, that notice to the other person does not satisfy due process. So posting it on the house for occupant does not satisfy due process on behalf of my client.
What's your position about where it should have been sent to this Florida address?
Actually, it's very easy. MCL 21178 E2. E2 mandates that the first thing that the treasurer does is search the local assessor's office for the address and name of the owner. If the treasurer had done that in this case, the assessor's office had the correct address in Florida. That's 78E. What the treasurer says is, I'm sorry, 78E2. What the treasurer says is that under 78I, I look at the register of deeds and find that address, but that's not what 78I is intended to do. E is a section that says, this is the address you send notices to. 6 is a section that says you have to send notice to all owners and persons identified in those 4 records. And those 4 records would be the land records of the Register of Deeds, tax records of the county treasurer, tax records in the office of the local assessor, tax records of the local treasurer. Again, treasurer looked at Register of Deeds for the owner under 6. 6 does not mandate addresses. E does, and the assessor's office had that address. Had they had discovery, I think that the record would have shown that the treasurer either did look at the assessor's records, had the correct address and disregarded it, or the treasurer didn't do that inquiry and violated the statute, section E, by failing to send a notice to that address.
What do you want us to do? Because it seems to me that the title to both of the properties is now in the hands of a bona fide purchaser for value, right? Somebody actually bought it out of a sale, right? For a substantial amount of money.
I know it listed 236. The problem with that is,
Right.
first, there's
But I mean,
one property.
Are we supposed to just divest these people of their titles?
That has happened in my other cases, yes. But the issue with the notices, especially to occupant, and in this case, I think it's important to take note of that fact, is that Mr. Parker was my client's tenant in the house. The notices that went to the house were received by him. The law in some cases, I think, I can't remember what case it was, the court had said it's presumed in the law that a tenant has an interest similar to the owner, so the tenant is going to give the owner those notices. Well, Holland says giving it to somebody other than the notice owner isn't good enough. But in this case, Mr. Parker received the notices, kept the notices, disregarded them because the notice said, if you're not the owner, disregard. And then he's the one that ended up with title to the property and is still in the house as of today. His
Right.
interest isn't aligned with the owner. He kept the notices, he got the house. After the treasurer learned every single notice addressed to my client was not delivered, the treasurer did nothing to investigate. And I say it's investigation would have required much because they already had or should have had the address on file with the assessors, which was the correct address. Discovery would have revealed in addition to the search of the assessor's record.
Can you stop for just 1 second? Because I don't think you can dispute that there were tax deficiencies, right?
No,
You're not disputing that.
I'm not.
Okay. So at the very least, the owners of the property had to have known that they were behind in paying property taxes, right?
Correct.
Yes?
And I do believe that Mullane versus Central Hanover Trust is a case wherein the court said knowledge of a tax deficiency is a knowledge of the foreclosure.
Right.
Okay, so the first part of the process is to send notice to the address where the assessor's office sent notice to. Treasurer never did that in this case. After the notices were returned, Treasurer never sent to the address where the assessor sent tax records to. As a side note, the biggest problem with the deed that the treasurer relies on, there was a 2016 deed to my client. There was a 2017 deed to my client. The 2017 deed is fraudulent. The company BPH that recorded it was involved in some questionable dealings as indicated by court records, was getting sued all over the place in state and federal courts. They filed this deed, but it wasn't a vesting deed. They just drew up a document and recorded it in the register of deeds, but not in the assessor's office. So I believe number two, the document that discovery would have revealed is that title check does a title history for treasurer, in my experience. Title check is a company that does a title search for the treasurer with these foreclosure proceedings.
Also, it seems like you're putting a lot of impetus on the treasurer to make sure that the notices that they're sending out are going where they're supposed to be. Like, there seem to be checks and balances built into the system. And beyond that, you want some sort of guarantee that the notices are going there, or there's actual notice?
No, and I think that that's a really good point, because the statute makes it very easy to understand where the notices should be mailed. Section I-6 identifies the owners. That's it. Section E says you send owner's notice to the address on file with the assessor's office. It's that very simple. That's what the treasurer did not do in this case. The treasurer never sent notice as required by the statute in 78E2. Due process required, once the notices were returned that were sent to the wrong address, that there be further inquiry. I think discovery would have shown that the treasurer did not do anything after the notices were returned. And that violates Mullane, Jones versus Flowers, Perfecting Church, whole host of other cases.
Ms. Boylan, would you mind moving on to the surplus proceeds argument?
would.
I think that's a much stronger argument than the one you're making.
Understood, Your Honor. Thank you. The bottom line with the surplus, they cannot use it as a sword and a shield. They did not include any notice in any delivered or undelivered, claimed or unclaimed. None of the notices that the treasurer ever sent during the entire foreclosure process complied with the Governmental Property Tax Act, period. They tried to send one 5 months after the last due date under the statute, but again, they sent it to the wrong address. So it in effect was a nullity.
Are you talking about the form that they have to send out, the one-page form that then the landowner can fill out, and send back in?
No. Under the statute, under the amended statute, section I.
Yeah.
It.
Okay. You're not even on T. I got it.
No, T is just a process. I'm talking about I. In I, the amended I, in the notices themselves, the treasurer has to include a statement that you're going to lose your property to taxes if you don't pay your taxes. A statement that, legal resources, the phone number and the email address to the State Bar of Michigan is a way to avoid the foreclosure process in and of itself. But significantly, if your property is foreclosed, then you have the right to claim surplus proceeds and the manner in which to do it and the time in which to do it. And so there's 4 different notices that the treasurer should have mailed that included that statement in it.
Well, right, but if Form 5743 had been sent as required by T, not I, that would have cleaned up the problems on surplus proceeds, wouldn't it?
Could you help me out with that form? Just, I'm familiar with the process, but I don't
It's a
know the form number.
one-page form. What happens is once a foreclosure sale occurs
Oh,
and there are surplus proceeds remaining,
Mhm.
under T, the treasurer has to send out Form 5743. And that's a one-page form that the property owner, now divested of title by the foreclosure sale, can file that form. And if timely done, that becomes the request for surplus proceeds. Now, I think that form was sent out for each one of the properties here,
no,
but I think your argument is it went to the wrong place.
no, it
Or is
wasn't.
your argument something else?
No, I think that Your Honor misunderstands that form. That form is available on the website and the treasurer created that form. That form is never sent and the statute doesn't require that form to be sent.
Wait a minute. I was on the panel on 3 different cases where there are published opinions, and maybe that's not the right number for the form, but that's how the T process proceeds.
The T process has to do with the recovery of surplus proceeds after the foreclosure, and they
Right.
have to file that form on or before July 1st.
Correct.
That form is never mailed to persons with an interest in the property. That form is available, but it's not sent to.
Every case I've been on that involved a claim for surplus proceeds is a fight over whether that form was sent or not. Muskegon County, Kent County, all of them.
The issue is whether the content of the notices that were sent during.
I get it, but
Okay.
what I'm saying is that the form is sent, it cleans up the problem as long as the dispossessed landowner gets form whatever number it is. I thought it was 5743, but if it's another number, it's another number.
What I know is in this case, that form was not sent. In this case, the form wasn't sent to anyone, wasn't sent to the house, wasn't posted, wasn't sent to my client. And in this case, under I believe is a section that sets forth the language that has to be in the notices that are sent during foreclosure. That language wasn't in there and I know you know
Right,
that.
you're right. I'm not disputing that. I'm just saying if the form goes out, it cleans up the notice problem from the earlier situations, at least as to a claim for surplus proceeds.
But that form wasn't sent.
Okay,
Uh,
that's what I thought you were saying.
Yes, that form wasn't sent in this case. I think what happened, and this is just my basic assumption. This was one of the first round of notices to go out after Raffaelli. And the treasurer didn't use an amended form. The Wayne County treasurer didn't use an amended form that the state treasurer had created. And so they were sending out old notices that didn't contain the language. They realized it and then sent it out after the fact, but again,
The only,
didn't send it to the right address.
yeah, the only evidence that I saw was that the mandatory language regarding the right to claim surplus proceeds was provided before the foreclosure was its inclusion in the certificates of forfeiture recorded with the register of deeds in this case.
They weren't.
Just the mandatory language that I understand the form wasn't sent.
With the register of deeds?
Was the inclusion in the certificates of forfeiture recorded with the register of deeds. That there was that mandatory language was included in there, but that was before the foreclosure. That's the only evidence I saw, the record.
It wasn't sent to my client.
Right, I understand the argument, I understand that argument. I was
All
just saying that, All right,
Your Honor, may I have that form number again?
I think it's 5740.
it is
you.
5743. You have time for rebuttal. Thank you, counsel.
Please the court. Mark
Morning.
Nagy on behalf of Wayne County and the Wayne County Treasurer, Eric Sabri. Nice to see you.
Good to see. Would you start at the back end and clean this mess up,
That is
please?
exactly where I was going to
Thank
do.
you.
Yes, thank you. And I think you've already clarified I was going to do the same. You had the correct form number. It is a state, not a county form, treasury form. I want to start with the assumption, we can go back to it later. If we start with the assumption that there's not an address problem, that the county was entitled to rely on the address that it used. I'd like to direct the panel to the appellant's appendix attachment A, which was the Wayne County motion for summary disposition. Then there are several exhibits, A through G, which are several notices. And exhibit G, the final exhibit, are what are called the notice of right to claim remaining proceeds that were sent to the addresses 8 weeks, I think it's May 9th, 2022. So admittedly after the foreclosure, but almost 8 weeks before the July 1st deadline to submit the form. And it contains all of the statutorily required information. The form was not submitted. There's a lot of case law that if this notice is sufficient, which we contend it is, then you have forfeited your right if you haven't met then the notice and motion deadlines.
Yeah, you're speaking a language that I now understand.
Yeah, I have a question. Sorry to
Yes.
interrupt you. So the court found that the mailed and posted notices of the show cause and judicial foreclosure hearings omitted the mandatory requirement to explain the right to claim surplus proceeds pursuant to T, okay, of the statute. And then you have the case of Enrique Kent County Treasurer, right? Which
Yes.
established that the former property owner is constitutionally entitled to receive notice
Yes,
regarding the right to claim the proceeds.
yes.
Okay, why shouldn't the omission of this critical information from the primary hearing notices constitute a violation of due process related to the deprivation of the surplus?
Thank you for your question, because I really do think that that is where the rubber meets the road. You've exactly hit why this is not a case to be sent back, and this is not a Kent County case. This is not a perfecting church kind of case, and the reason is kind of twofold. First of all, if we go back to the big Muskegon case, the published case that said this whole process is constitutional, the argument by the respondent in that case was that the notice should be post foreclosure of the right to surplus proceeds. And the argument was everything pre-foreclosure is about the right to retain the property or redeem it. Everything after the foreclosure is a separate property right.
Right. You
So-
don't even know if there are going to be surplus proceeds.
Right.
Until the thing goes to auction, right?
Right. And Muskegon said, well, maybe it should be that way, but this is a constitutional statute. We're not going to second guess the legislature. If they want to put that notice in pre-foreclosure, they can put it in pre-foreclosure. At least it's telling you if there's surplus, you have the right to seek it. And so the court did not go with the respondent's argument that this has to be post-foreclosure notice. But the point being, from a due process standpoint, is it can't be constitutionally insufficient to give post-foreclosure notice of the right to seek surplus, as long as you have minimal requirements of due process that you've had an opportunity to seek your surplus. And here, when we look to Exhibit G, which is a copy of the notice called Notice of Right to Claim Remaining Foreclosure Proceeds, it was sent to the address that we can talk about, 8 weeks before the form was due.
Counselor, is there proof in the record that this notice was sent? Proof of mailing?
I think in almost every notice case, respectfully, Your Honor, I think we're relying on the affidavits of the, yes, I think regarding the Exhibit G notice. I would have to see what the county submitted with their motion for summary disposition. And where they were, so Exhibit A to the appendix of the appellant is the motion for summary disposition. And where they reference Exhibit G,
I did not see that, so I would be very interested in. I only saw the notice.
I think what we'd be relying on is the postmark, Your Honor. It appears that Exhibit G copies of notices are complete with postmarks, which to me really then comes down to the argument about the address issue. If whether, going back to and I'm not ready, I don't think, unless the court's ready to move on to that issue of address, but I think the point being is that these were at least mailed. And there is an affidavit, I think, that predates that does not go to that notice, but
It's a different notice,
right,
Yeah,
right.
Okay.
Okay. So, but going back to Your Honor, Judge Garrett's question, I just kind of want to close the loop on if what the statutory scheme is that May 2022 notice really should have been a pre-foreclosure notice. I think the statute itself, as well as the case law around due process, satisfies that you don't get to completely unwind or undo a foreclosure or get surplus if the defect didn't substantially impair your due process rights, your ability to make the claim. And I think here we have in spades that all through the process, the notices were sent in time, either for the foreclosure for that piece or for the surplus proceeds for that piece.
But there's a world difference between unwinding the foreclosure on the one hand, which really creates problems, and unwinding the disposition of the surplus proceeds, right?
I agree. There is a much cleaner path towards that.
Yeah.
But the question then becomes legally whether that's the right path. Does a person who gets this notice 8 weeks ahead of time still get to say, well, I somehow didn't get the minimal requirements of due process, so you have to reopen what the legislature said and the case law has said you forfeit if you don't timely submit the notice of intent and then make a motion and before I don't want to jump all over. I wanted to bring one case. I'm not going to rely on it. It's not in the briefs. It's not even published, but your Honor, Judge Yates was on the panel of a case that Wexford County was the defendant. And so once we got the panel assignment, it brings up all of the same notice issues. It's all under subpart 78I. It's all of the same process of going from looking at the deed to the mailing, to the personal visit, to the posting, to the publication. And that was case number 365351 of this court, unpublished, dated March 14th of 24. So to the extent you're interested in seeing how these kinds of issues were dealt with in that opinion, it was an affirmance in favor of the county and the county treasurer out of Wexford. If we want to.
I would, yeah, if you can move on to the next issue, that'd be great.
Thank you. I do believe that every aspect of Part I, and forgive me, I was over there looking as I heard a lot of emphasis on E2. I couldn't find it in the table of authorities. I'm not sure that I could find it in the appellant's brief. I'm therefore a little flat-footed in saying what E2 says, but I firmly believe that as we've briefed, everything that we're talking about is governed by 78I, the notices. And when you look at 78I, I really appreciated your comment, Judge Patel, is that if you take all the arguments at face value, then the treasurer should have known that if he had just gone to a previous deed, then the Florida one is the right one. And that's only for one of the two properties, when in reality, you could have anyone say, well, no, Florida wasn't right either. You'd have to look to the third. But if you just keep going down the chain of title, you'll get to the right one. That's not an obligation, and that would be a tremendously overly burdensome obligation. When you look at all the things that already were done in this case, to go from the deeds to the mailings, to the personal visit, to the posting, to the publication, adding on to that you have to question whether your most recent deed is correct is not plausible. It's not practical. I know there's a lot of strong statements in the brief that would have been right, but how does the treasurer know that even going to the last deed would have been what that person says is the right address? And the same goes to this idea that it was a fraudulent deed. Again, it's the public record. It's the record that a treasurer relies on. And if we're now saying that we can't rely on the record because it might be fraudulent, I don't know where you shift that burden. It's the same kind of argument that the tenant threw away or hid the notice, or Mr. Parker had if we can't follow this process to do then the next step of taking it physically to the property because it might be someone who has ulterior motives. I mean, where does it stop of putting all the burden on the public entity to figure out all this stuff?
Right. I presume that there's a physical assessment notice that you have to pay to your summer taxes and your winter taxes. And if I'm a property owner and I don't get that one or two times, I'm looking for it because I'm thinking, okay, how much do I owe in property taxes? And so if there is some sort of bogus deed in the chain of title, that should be picked up sooner rather than later, not by the treasurer, but by the property owner, right?
Yes, I would assume so. And again, even if, I think when the word fraudulent was used, it was meant to say that maybe that person wasn't authorized to record it, but I don't think that's even saying that it's a wrong address. It's just using the property owner's Michigan address instead of their Florida address. So we don't even have a situation where this deed is causing the notice to go to some other place, some
Right.
other property. Yeah. And then I guess, so I do think that the treasurer complied with the statutory mandates to not only check through the list of all the different forms using what an address he's entitled to rely upon in the deed, in the chain of title, the most recent one, all the way down through the posting. I think it's a little unreasonable to say, well, we don't have a copy. The only thing we don't have a copy of is the thing that was posted. Well, that's because that was a physical item and photos were taken and provided of the home. So of course the one thing we don't have is the physical item that was left at the home or at the property in each instance. And so when you go through all of those items, I think in this case, it's a really hard case to say that the minimal requirements of due process were not met. And that's what I believe takes it out of the perfecting church line of case, the Kent County line of case. In some cases, you can say they flat out just didn't do it. They didn't have notice. That's what those cases were. I think here we just have a little sort of picking on the fringes of technicalities that don't go towards whether the notice was properly sent, whether due process was complied with. And that's why I think very much like the Midway North case, the Wexford County case, and some other cases we've cited, that affirmance is in order here. There was constitutionally sufficient notice that satisfied due process, both respect to the foreclosure and the surplus proceeds. And to do anything to upset that, I think would be contrary to the statutory scheme. Thank you.
Thank you, counsel.
What I'm saying is that the treasurer had the correct address and disregarded it. And they kept doing the same thing over and over and again, expecting a different result. They kept sending notice to the wrong address. The very first address, the tax got turned over in 2020 in this case in March. By December of that year, the treasurer was required to look at the assessor record, find the address, and send notices to that address. That's the address that they did not send it to. Subsequent to that, they sent notices to all kinds of other addresses that were all returned. Due process requires, once those were returned, they had to conduct a reasonable inquiry into what the correct address should have been, and they had it from the December 2020 search of the local assessor records. So what they say is doing the same thing over and over again, expecting a different result, is the definition of insanity. In this case, sending the notices repeatedly to the wrong address, having them returned, and not doing anything about it, violated due process. Now, I'm talking about the surplus issue. The treasurer violated every mandate in the statute by not sending the notice to claim surplus proceeds in a timely fashion, okay? Now, in my client's case, they're claiming you did not comply with the statute by sending the notice to the treasurer to claim on or before July 1st. Interestingly enough, when the statute was amended, the legislature treasurers rushed to get the deadline for filing a notice to July 1st, okay? At that time, who knows whether there's any surplus, because the auctions don't take place until later. And historically, owners sometimes that don't receive the proper notice learn of it when the auction sale signs go up in the yard. So they don't file a notice by July 1st. The auction signs have to go up by July 15th, and then it's too late for them to claim surplus proceeds. So what I say is the treasurer is stopped in this case from claiming my client missed a deadline, but we missed every single deadline and it's okay, but you have to comply with it. Due process is violated in this case in the taking of my client's houses and in the failure to provide timely notice of the surplus proceeds, the right to claim surplus proceeds, and sending it to the wrong address. Thank you. Any
Thank you
questions?
so much. Thank you, counsel. No questions for myself. You have any questions? All right, no questions. Thank you. You both. Great to see you. Have a great day. Thank you. This matter will be submitted. Calling item number 6, 368-571, Decora Construction Incorporated versus SAA Management LLC. Good morning. You may
Morning, Your
proceed.
Honors. Alec Durian on behalf of the defendant appellant SA Management LLC. At this time, I'd like to reserve 5 minutes for rebuttal.
Thank you.
Your Honors, this case is about the trial court's multiple procedural failures that have now resulted in this appeal. First off, the initial decision to allow the appellee to file a first amended complaint after motion for summary disposition was granted with prejudice, and that first amended complaint was exactly the same as the complaint that was ultimately dismissed. The decision to deny a second motion for summary disposition on the exact same issues. And then third, ultimately, when the trial proceeded on damages, an improper award of case evaluation sanctions on a first amended complaint that never was actually case evaluated. Now, for the purposes of this court's review, the first issue is whether Judge Groner's initial decision on the motion for summary disposition was with prejudice. And then second, whether that amended should have been permitted in the first place. And then third, whether when there was a shift after Judge Groner retired, it was shifted to Judge Barry. Ultimately, whether that second motion for summary disposition should have been granted. Now, the court I know is aware of the facts. Just briefly, the pertinent factual issues are the initial complaint was filed in February of 2020. This case was transferred on 2 occasions. First, it was transferred on March 29th of 2021 to Judge Groner, and then eventually on January 3rd of 2023 to Judge Barry. And in that time marked key decisions that ultimately led to these procedural issues. Now, when Judge Groner was involved, he reviewed and made a decision on a motion for summary disposition on the breach of contract claim. He then decided to grant leave to file a first amended complaint, but in doing so, he addressed on the record to trial counsel that if that first amended complaint is the same as the one that he previously just dismissed, he will deal with it at that time.
Okay, stop for just a second. The first grant of summary disposition was under 2.116C what?
Your Honor, it wasn't specified in any of the briefing, unfortunately.
Right, because if it was under either C8 or C10, leave to amend had to be granted under 2.116I5 unless it would have been futile. Is it your argument that it was under 8, 10, or something else?
Your Honor, under 8 or 10, it was an adjudication on the merits, which would be a decision with prejudice. I mean, under 8.
I get that, but I mean, leave to amend should have been allowed under 2.116I5 if it was under 8 or 10.
Your Honor, on that issue, the futility argument would come into play,
But nobody made the futility argument.
Your Honor, it was addressed at the time of the motion for leave that it was addressed that this was exactly the same claim that was being filed. Judge Groner acknowledged that it was in fact the same claim. And then later, essentially the same motion for summary disposition that Judge Groner was granted was filed, and Judge Barry effectively overruled her co-equal judge by changing that decision and allowing the complaint to proceed.
Okay, and you got to another point that I've got to know. This thing went to a jury trial on damages, but before that, there was a grant of summary disposition in favor of the opposing party, right?
Correct, Your Honor. There was cross motions for summary disposition.
Presumably under C10 or I2, right? 2.116 C10 or I2. In other words, the court considered materials and it found no genuine issue of material fact, right?
You're referring to Judge Groner's opinion?
I'm referring to Judge Barry now.
Your Honor, when Judge Barry examined it, I mean, no facts had ultimately changed. The issues before the court were the same.
Procedurally, what was the ground under it? We are so lost in this case because I can't even figure out what court rule was invoked to do any of this. When Judge Barry granted summary disposition in favor of the opposing party, was it under C10, I2, or something else?
Your Honor, I mean, my position would be that that would be under C10, and I guess you'd be referring to the denial then, is that correct?
No, Judge Barry found liability. She had to have, otherwise there wouldn't have been a trial on damages. What was the basis of her finding of liability on your client's part?
Your Honor, and respectfully, I don't have the transcript in front of me of that issue, but it shouldn't even have gotten to that point where Judge Barry was ultimately making that decision.
But you're not even letting me get to the next question because we can't even figure out what court rules invoke. But I presume the claim on which the jury was asked to assess damages was a breach of contract claim, correct?
Correct, Your Honor.
Okay. So what we know then is that it almost certainly would have been under C10 or I2, right?
Correct, Your Honor.
Okay. And so your complaint is that Judge Barry didn't even have the procedural right to allow them to prevail on the merits of their breach of contract claim, right?
That, and in addition to that, that Judge Barry should have never even been in a position to make a ruling on that.
Right.
claim.
It's a procedural problem, though, not an evidentiary problem, right? Not a question of no genuine issue of material fact, either by law of the case or something else, some other theory that completely escapes me, that once Judge Groner made the decision to foreclose that breach of contract claim, that it was forever lost. And if they didn't appeal, that was the end of it, right?
Your Honor, I'm not fully understanding the question, but on Judge Groner's opinion, he addressed the facts at issue and he addressed the notice section. Later, when Judge Barry addressed the issue, she had indicated that Judge Groner has already hashed out these issues. She's not going to stand on that opinion and not going to rehash that decision. But then ultimately she went contrary to Judge Groner because at the time that the first amended complaint was filed, the notice provisions had still not been complied with. So Judge Groner had actually made that factual determination on the initial motion for summary disposition with respect to the notice requirements.
Okay, but maybe you totally disagree with the way I see the case, but it looks to me like Judge Groner granted summary disposition in favor of your client under C10. But he granted leave to amend, as he should have under 2.116 I5. The amended complaint came in. That put the breach of contract claim back in issue because it was just on an amended pleading. And then Judge Barry picked up the case, looked at it, and granted summary disposition to them under C10 or I2. I don't know which. That's wrong in your view.
No, Your Honor, it's not necessarily wrong, but the issue with the amendment is that the amendment was the exact same claim that Judge Groner granted the motion for summary on. That was the claim that ultimately was filed. Now, I can presume that if Judge Groner had reviewed this and looked at the second motion for summary disposition, he likely looks at this and says, I already decided this issue on the first motion for summary disposition. Nothing has in fact changed with respect to the notice requirements. Notice was still ultimately not provided. So Decorah had in fact breached the contract first, which would again result in a dismissal and a granting of the second motion for summary disposition.
One more question, and I promise I'll shut up and let you argue. The last question is this. If we find that Judge Groner was wrong in granting summary disposition in the first instance to your client under C10, then everything that happened after that was okay.
Your Honor, yes, in theory, yes, that would be okay. I mean, if Judge Groner was incorrect in granting summary disposition on the notice issue, the appeal issue.
It doesn't matter if the amended complaint stated exactly the same breach of contract claim. It shouldn't have been knocked out, so it could have proceeded.
Ultimately, that claim would have survived at that point. Likely the trial would have taken place at that point.
Okay.
And
so there's that original sin, but after the original sin, if it wasn't really an original sin, everything that happened was correct.
Your Honor, essentially, yes. I mean, our position is obviously that Judge Groner's decision on the motion for summary disposition was the correct decision. I don't believe there was any dispute on the notice issue. There's arguments on how that notice section should actually apply. I mean, the contract is very clear that notice needs to be provided. Ultimately, there is a cure period and then suit can be filed. I mean, the notice would be a condition to filing the lawsuit and notice was ultimately never provided. Now ultimately, one of the issues with Judge Groner's opinion is if it's ultimately with prejudice, and I don't think it matters on a C8 or a C10, it looks like if you look at his opinion, it was made on a C10 ruling because he does go into those facts. But essentially looking at his opinion would be asking the court to make this determination that the complaint doesn't in fact have any merits, but we're not actually looking at the merits of the complaint. So in practicality here, by him granting the motion for summary disposition, it is implied that it is with prejudice. Now, at that stage, the only remaining claim left at that point was a lien related claim. And it wasn't addressed in the initial motions for summary disposition. However, in order for a construction lien claim to survive, there needs to be an underlying contract claim as well.
Yes.
So when Judge Groner dismissed the breach of contract claim, the lien claim should have also been dismissed. He addressed the unjust enrichment claim because of the contract issue. So in reality, while we agree with his granting, it should have been a granting on all issues, which then Judge Yates probably solves the issue because the entire case is dismissed. At that point, it's without prejudice. The case is then refiled at that stage. Maybe the notice is then a different situation. If a letter is sent on the notice, it essentially resets the facts. However, there is likely a statute of limitations issue at that point.
Right. Well, the Construction Lien Act is just an enforcement mechanism for a breach of contract claim.
Correct, Your Honor.
Right.
So
Yes, I agree with you on that.
That lien claim that survived, I mean, wasn't a viable claim that ultimately survived at the point of his decision. Now, on the futility issue, there is extensive case law on it that futility exists if the amendment is legally insufficient on its face or merely restates the allegations that are already made and dismissed. I mean, here, when we look at the First Amendment complaint, paragraphs 14 through 21 are identical. The case doesn't go away and come back. The notice section is never complied with. And essentially, Decorah is permitted in hitting a reset button and starting fresh. I mean, if Judge Groner was granting that first motion for summary disposition, when he looked at the motion for leave to amend and saw that this complaint was exactly the same, it should have been denied for futility reasons at that point. And that would have alleviated any concerns on the second motion for summary disposition issue.
It seems a little absurd, actually, like an absurd result to me in terms of reading that provision, because what you're saying is that first, you're treating this notice provision as a condition precedent to filing suit. I'm not sure that I read that provision that way, but you're saying that if it's a condition precedent to filing suit, even if they go back and meet that condition precedent, they have now, under res judicata, they have no remedy to file suit. How does that comport with justice on the merits?
The result would be different, Your Honor, in that situation. If the entire case is dismissed, even if it's without prejudice, and then they go and they comply with the notice requirements and then refile the case, there are additional arguments that could be made. I mean, I don't have exactly the dates on the contract in front of me, but potentially at that point, their failure to comply with that notice requirement could put their backs against the wall on statute of limitations issue. It could raise other issues with respect if notice is provided, then my client could have had an opportunity to cure and make necessary payments that he could have made. The case could have been voided entirely, but instead of complying with the notice provisions, they decided ultimately we're just going to file suit. We're going to ignore the notice provisions and we're going to proceed at the trial court. And they should not have been permitted in doing that, Your Honor. Now, the last issue on the second motion for summary disposition, I mean, because of Judge Groner's decision on the first motion for summary disposition and then ultimately granting the leave for amend, the second motion for summary disposition presented the same issues as the first. And Judge Barry went as far to even acknowledge Judge Groner's opinion. She indicated that she was not going to rehash those issues in that opinion, but then ultimately she makes a decision that effectively overruled her co-equal judge. There was never a motion for reconsideration filed. There was never a leave for appeal sought to this court to appeal those issues until this stage, but they got relief by way of an appeal by a co-equal judge, essentially denying the second motion for summary disposition on the same complaint. Now, Judge Patel, that is where the res judicata issues and potentially the collateral estoppel issues come into play, is at the second motion for summary disposition when nothing has changed and it is the exact same complaint and notice still has not been provided then Decorah has in fact still been the first breach of the contract and the case should have been dismissed. I mean,
That's not res judicata or collateral estoppel. That's law of the case. Res judicata or collateral estoppel is to block another lawsuit. This is the same lawsuit, right?
yes, Your Honor, and
I mean, you're totally misapplying it if you call it collateral estoppel or res judicata.
and really it's kind of just the entire law of the case. That is the issue here, is that they essentially got the chance to litigate the exact same case on two occasions with two separate judges, and that should never happen at the trial court level. The last issue of this, beyond the motion for summary, the motion for leave, is the case evaluation issue. Now, as I mentioned, the original complaint was ultimately filed in February of 2020. A case evaluation took place on December 16th of 2020, and there was an award of $100,000. Decorah had accepted that award, and SAA management had ultimately rejected that award. Now, that would initially give rise to case evaluation sanctions under the old version of the rules, MCR 2.403. However, that operative first original complaint was later on dismissed. And then a first amended complaint was filed. And after the first amended complaint was filed, there was never a second opportunity to go back to case evaluation, argue the issues, and now have an opportunity to either accept or reject an award on the first amended complaint. Now, Decorah has provided supplemental briefing on this issue. It was the Webster case that ultimately, the decision in that case is completely distinguishable from this case. In that case, the case was ultimately filed, case evaluation took place, and the rules were amended in the time that it was filed until when the trial took place, but it was the same case the entire time. The issue here is that we are working with a second complaint that never went to case evaluation. So once the rules ultimately changed before that first amended complaint was ultimately filed, case evaluation sanctions should have been out the window entirely at that point, because now the court is operating with the first amended complaint filed in the summer of 2023. The rules are amended in 2022. So when that first amended complaint is stamped by the court and is the operative complaint, there are no longer case evaluations.
So just to be clear about this, you're arguing that the triggering date to decide which version of the case evaluation rule applies is not the date on which the case was initiated by the filing of the first complaint. Rather, it's the date the amended complaint was filed.
Correct, Your Honor.
And that's entirely outside of the amendment. The amendment had already occurred by the time that happened.
That is correct, Your Honor. And the other issue with it, Your Honor, is that the first amended complaint never went to case evaluation. So the first, they were operating on the 2020 case evaluation, and now 3 years go by and they gather fees and get an award on a first amended complaint. That is the one that ultimately proceeds to trial. Unless there are any further questions, I'll reserve my remaining time for rebuttal.
Other questions?
No, thank you.
Okay.
Thank you, Your
No
Honor.
question. Thank you.
Good morning, Your Honors, and may it please the court. My name is Simone Capadia, and I represent plaintiff appellee / counter appellant Decorah Construction. With the court's permission this morning, I'd like to reserve about 5 minutes for Decorah's co-counsel, David Ganem, to speak if necessary. So this morning, there are a number of issues regarding this morning, but before we're getting into what is actually being appealed in this case, I would like to draw, as I did in my brief, to just point out that SAA is not appealing its counterclaims against Decorah. So in the case that if this court does remand this case, SAA will not be able to resurrect the counterclaims as they haven't been part of this appeal. Now, regarding what is at issue in this case, regarding Judge Yates's questions regarding what was Judge Groner's original July 2022 opinion granted under, it was granted under MCR 2.116 C10, and that's because Judge Groner looked at information outside of the pleading, specifically the notice communications between Decorah and SAA, which makes it a C10 motion. And regarding whether or not Judge Groner was correct in dismissing Decorah's breach of contract claim, the cross appeal says that it should never have been dismissed in the first place because the notice provisions is a notice to terminate the contract and not a notice to file suit.
But let's assume you're right about that, because you have this cross appeal and you want us to make that determination. If we make that determination in your favor, Is there any reason to remand this case? Does anything need to be redone? Because it looks like you won on the merits on liability in front of Judge Barry under C10. Then you had a trial on damages on the breach of contract case, claim, right?
Yeah.
It couldn't have been on the construction lien claim because you can't recover money on a construction lien claim except for attorney fees and so on, right? So is there anything to send it back to clean up?
I would argue no. And in my reading of the hearing transcript of Judge Barry's May 2023 summary disposition hearing, is that I understood Judge Barry to have granted summary disposition under I-2. And
That's what I thought too.
That was my reading of it. And regarding, so Judge Barry came to the conclusion that Decora's breach of contract claim against SAA was successful because of the fact that SAA had breached the contract first because SAA stopped paying Decora. And that's in the record. For example, I believe it's in the record at Appellee's Appendix, Decora's Appellee Appendix, Appendix 1, which is the notice communications between the two parties where it's clear that SAA had stopped paying Decora.
Right. And hadn't even Judge Groner made that determination? It came up in the context of the first breach argument in terms of a defense. But I mean, Judge Groner essentially, as I understood it, said there was a procedural hurdle that prevented you from going forward on your breach of contract claim. But he had to get to the merits anyway on the first breach affirmative defense. And so he ruled in your client's favor. But for the procedural hurdle, that would have been the outcome. So it's not correct to say Judge Barry changed the result, right?
I agree, Your Honor. In my view, so if this court finds that Judge Groner was correct in dismissing the breach of contract claim because of a procedural issue, Judge Groner did find that it dismissed SAA's counterclaim against Decora on the basis that SAA had breached the contract first, which is exactly what Judge Barry referenced and discussed in the hearing, the May 2023 hearing, in granting Decora's breach of contract claim against SAA.
And just to be clear, Judge Groner, not Judge Barry, was the one who allowed the amendment of the complaint, right?
That is correct.
So if you look at it that way, Judge Barry didn't overturn a single thing Judge Groner did, yes?
I agree. Yes, Your Honor.
Because that's how I see it.
That is.
I mean, this argument about res judicata or collateral estoppel law of the case, I don't think it has any application here at all.
I agree, Your Honor. And I would also point out that res judicata and collateral estoppel cannot apply because they require valid final judgments.
Right.
Judge Groner's.
Right.
And just,
Right.
yeah.
It's not that.
Sure. But Judge Groner's opinion was not a final opinion. There was the slander of title claim, SAA slander of title claim that was still relevant, and Judge Groner did not make a ruling on the construction lien claim. And I believe the
But the construction lien claim can't result in a damages award. I mean, you got your attorney fees under it, but I mean, it's an enforcement mechanism.
as the position that we take in our brief is that under Ronich and Dane Construction, my understanding is that the construction lien is separate from a breach of contract claim. They're interrelated.
Right. But it's an enforcement mechanism. It's not a mechanism to recover damages. I mean, you can foreclose on the property to get the outstanding obligation paid. That's it, right?
So I would argue that they are separate, separate claims. So that is.
They're separate claims, but it doesn't generate a damage award.
And to an extent, they are related in the sense where the damages can be related to how much was related under the contract.
Right.
But my position is that they are separate claims and that dismissal, for example, dismissal of a breach of contract claim does not dismiss a construction lien claim. And I would also argue that I think there was some discussion earlier with the prior argument is that there was discussion regarding the law of the case doctrine. I would argue the law of the case doctrine doesn't apply either because the law of the case depends on cases going up and down on appeal to trial courts and the Court of Appeals. So regarding our position is that Judge Groner's initial dismissal of Decora's breach of contract claim was incorrect because of because it wasn't a notice. Notice was not required to file suit. Notice was required to terminate the contract. And our position is that in the case that this court disagrees with that and believes that Judge Groner was correct, in allowing Decora to amend its complaint. And that's because Weimers versus Kara says that if a court grants summary disposition under C8 or C10, that a court must allow the parties to amend their complaint unless doing so would not be justified. And that then Weimers versus Kara cites MCR 2.116 I5. So Judge Groner was not incorrect in allowing the amendment to go forward. And Judge Groner was, the motion to amend was very clear that the difference between the claims is that Decorah had then complied with the condition precedent that Judge Groner felt was necessary to do so. And I would point the court to the case of Yo versus State Farm, which is a similar case regarding dismissal of a case because of a non-compliance with the condition precedent, allowing the case to come back. And I think that the next argument that we had was regarding the case evaluation sanctions award. We would point the court to the supplemental authority that we filed. That was Webster versus Osgothorpe, which is a case that just came out from the Michigan Supreme Court, which says that case evaluation sanctions is to be considered under an abuse of discretion standard. And in this case, the case was initially filed in 2019. The case evaluation was in December 20, excuse me, I'm sorry, I'm reading the facts from Decorah, but from Osgothorpe. But essentially in this case, the case was filed in 2019 as well. The case evaluation happened in December of 2020. Judge Groner dismissed the original complaint, the original breach of contract claim in July of 2022, and the case evaluation rule changed in January of 2022. But our argument is that the only difference in the breach of contract claims is that this
Tell me this, because I'm struggling with this. At best, you have a straddle case here. No matter what you do, it at least started while there was case evaluation sanction provisions available, but when it ended, they didn't exist, right? Now, Webster's not an automatic application of the right to sanctions. There has to be some sort of horrible injustice, right?
right, there has to be.
How is there any injustice here when you can get your attorney fees under the Construction Lien Act? I don't understand why this is one of those rare cases where there's so much prejudice if you're denied case evaluation sanction when you're going to get your attorney fees under the Construction Lien Act.
So I would argue that, yes, I agree. And also Judge Barry's order makes it clear that there was not going to be allowed a double recovery under the construction.
Well, there better not have
Exactly,
been,
right.
right.
And nor should there be. I agree that nor should there be. In this case, because the case initially started before, to use your term, Judge Yates, was a straddle case where it started before the rule changed. The point of the Osgothorpe talks about, Webster talks about how the point of that is to, the point of the case evaluation sanctions is to facilitate a settlement or facilitate parties to talk to one another. And in this case, the parties had an opportunity to do that. Decorah accepted the settlement and SAA did not. The case then continued on for many more years and ultimately ended up going to a jury trial on the issue of damages. So we would argue that the trial court, Judge Barry, did not abuse her discretion in allowing case evaluation sanctions to be, allowing Decorah to get case evaluation sanctions against SAA. That is all that I had for the court this morning. If there's any further questions.
No, thank you.
Thank you.
Good morning.
David Ganem, may it please the court. I was the plaintiff's attorney during the trial and during the entire discovery and litigation process. Let me just explain to you, because sometimes things are lost between trial, history and coming on appeal and trying to give you a flavor of what was going on. And I appreciate all your questions so far. But there was an unfortunate error, in my opinion, by Judge Groner when he dismissed the breach of contract claim originally. He interpreted, and Judge Patel, you hit it right on the nose. He interpreted the contract like there's some condition precedent necessary before we can file a lawsuit. Absolutely not true. The contract, this paragraph 6 in the contract that talks about remedy says, if you want to terminate, you give 30 days notice. They have the right to cure. And if they don't cure, it will be automatically terminated. It has nothing to do with condition precedents. In fact, our law says if there's a condition precedent, it must be explicit. trial courts nor this court. You can't read that into the contract. Just simply can't. But he rectified that when we filed a motion to amend the complaint. We sent a notice like the trial court thought we needed to, waited 30 days. They did nothing, of course, and we refiled it. And that was the difference.
I thought you sent notice too. Why is opposing counsel saying that notice wasn't sent? I'm a little confused.
He's claiming notice, he may be claiming notice wasn't sent before we filed the original lawsuit. And by the way, we argued in that motion, it was. My client said multiple texts saying, you didn't pay, you owe money, you didn't pay, you owe money. There's only so much time I can go on. Judge Groner thought there must have been some type of more formal notice that was necessary. We disagreed, but we complied anyway. So we filed the motion, we got it. The judge did grant that motion. And the difference between, there's realistically no difference between the claims. It's breach of contract. You didn't pay, give us our money. He wants to say, well, we didn't even litigate the amended complaint, so therefore case evaluation sanctions shouldn't apply. But on the other hand, he's saying that's the exact same complaint, should have never been allowed to be filed.
The argument they seem to be making is that it was like a failure to exhaust. I'm not saying that it is, but we see that all the time. For example, if you want to try to come through the administrative process, you have to exhaust your administrative remedies before you can come to court. This seems to me to be akin to that. And when there's a failure to exhaust, it's not with prejudice, it's without prejudice, because nobody ever gets to the merits.
Judge, everybody here, everybody in the audience, and all of you know without being told, if an order is with prejudice, it must state so. If it doesn't so state, it is without prejudice. I don't know how they can say with a straight face, this was dismissed with prejudice, therefore some kind of res judicata claims. Judge Barry overruled nothing of Judge Groner. She actually, in fact, by the way, just as an aside, Judge Groner ruled in his summary disposition order when he dismissed the complaint, the breach of contract part of the complaint. He said the defendant breached the contract. He goes, he didn't pay, but I'm dismissing it for these reasons because no notice was sent. Again, we argued otherwise, but I filed the counter appeal or the cross appeal because in the event that became an issue, that's why we brought it up. But Judge, to your point, Judge Yates, if this court affirms what happened in the trial court, my appeal, the cross appeal, does become moot. There's nothing that needs to go back. Okay, I don't think there's any question about that. So in terms of the case evaluation sanctions, the same claim was evaluated, that was tried. They knew it. They knew it going into trial. They took the chance. I think the law was pretty clear beforehand as it comes to rules that change in the middle of litigation. It's at the judge's discretion, which rule would apply, old rule or new rule, depends on who relied on it, how much time went on.
It's not discretionary. I mean, the way the Webster is framed, there has to be some manifest injustice. I forget what the term is, but some manifest injustice to deny case evaluation sanctions. Because ordinarily you apply the rule that's in force when you get to that determination. And I see no injustice, manifest or otherwise, when you can get your attorney fees and did get your attorney fees under the Construction Lien Act.
Well, I agree, but I think that Judge Barry was correct. She awarded them under both rules, the Construction Lien Act and the case evaluation rule.
Right, and you can't get double dip.
And that the judgment is very clear on that as well. So all we ask is that this court affirm the trial court in its judgment and all its issues. And if for some reason this breach of contract issue, the way it came up in the trial court is an issue, that's why we have the cross appeal. You can always grant our cross appeal. And counsel did mention in his argument something about, well, because there could have been some issues that prevented the amended complaint from going forward, like statute of limitations. Absolutely not. This contract was signed June 25th, 2019. The statute would have just run out June of this year, 2025. There's no statute of limitations issue. Those are all red herrings to try to create some kind of injustice on the defendant. Defendant went into trial. He refused to even offer money. He thought very sufficient in his position. He filed a counter complaint that co-counsel they defended, and they didn't even have an expert, which is why their counter complaint was dismissed. They had no expert testimony, and in order to present some type of proofs of deficiency in construction, it requires experts. They had enough. So in any event, we ask this court just simply to affirm. Thank you.
Your Honor, on the notice issue, this is a classic example of trying to put the toothpaste back in the tube. when they filed the complaint, they didn't provide any notice. And Judge Groner ultimately concluded that Decorah had first breached the contract because they did not find the notice. It's not a termination requirement, but the contract says that notice must be provided and then an opportunity to cure must be provided. When SAA management gets no opportunity to cure, that situation cannot be rectified when the lawsuit is already pending. There's already claims on a lien. There's already a breach of contract claim. They can't go back and say, okay, now you can cure, but this lawsuit's already pending. You have to
Are
deal
you
with it.
denying that they gave formal notice after Judge Groner granted summary disposition for your client and then waited 30 days and then filed their amended complaint?
Yes, Your Honor, the opportunity for notice had already since passed.
No,
They
no, no,
had
no, but they gave you notice, right? As a matter of fact.
the notice argument is essentially the lawsuit. You were aware of the lawsuit, you're aware of the claim, so that's the notice that you receive is logically how this flows. They never provide notice at the time that the complaint is ultimately filed. On Judge Groner's decision, they indicated it's made under C10, which indicates that Judge Groner had in fact looked at all of the facts before him and made a determination that there is no genuine issue of material fact that notice isn't provided and they first breached the contract. Once that determination is made that Decorah had first breached the contract, that's the end. They can't.
I don't think it went so far as saying that they first breached the contract. I think that he said that notice hadn't been provided, but then also made the determination that your client had breached the contract.
Yes, Your Honor, but the indication and ultimately why the dismissal was provided is because Decorah had first breached the contract because they failed to comply with Section 6 of the contract.
I think he saw that not as a breach, but as a failure to meet a condition precedent to filing suit, not as a breach leading to termination.
Your Honor, under either situation, if it's a condition or if it's it would result in a dismissal either way. If they don't provide notice as they're required under the contract, it would, one, be a condition, but two, would also be a breach of the contract because it didn't comply with the contractual terms. Your Honor, with respect to the amendment and its justification, when the case is exactly the same, that right there is a prime example of futility that there's no justification for the second complaint when, again, they haven't complied with the notice terms and now they refile the exact same complaint that then proceeds. On the case evaluation piece, they argue that case evaluation is designed with an opportunity for the litigants to settle versus proceeding. SAA management was successful on the complaints that ultimately went to case evaluation. SAA received a dismissal on that complaint. And then later on, the first amended complaint, they were awarded the case evaluation sanctions on that issue once it was filed. We're asking this court to determine that the decision by Judge Groner was with prejudice and should have resulted in a full dismissal of this case, including the lien claim. And Your Honor, even if the lien claim, if Judge Groner's decision is upheld that the lien claim should have also been dismissed, then SAA's slander of title claim would still survive because they filed the lien that was improper. We're also asking this court to reverse the decision on leave to amend and also reverse the decision from Judge Barry on the second motion for summary disposition. But in lieu of all of this, if the court does not agree on any of those issues, then we're asking the court to reverse the decision on the award of attorney fees based on the case evaluation sanction issue. Thank you for your time today, Your Honors.
Thank you, counsel. All right, that matter will be submitted. I want to thank everyone for the morning docket. We are going to take a brief recess before we begin our afternoon docket. So thank you. Good afternoon, everyone. My name is Christina Garrett. Sitting with me today are my colleagues, Judge Seema Patel of the Second District and Judge Christopher Yates of the Third District. We welcome you to the afternoon session of our November 2025 case call. Just want to go over a couple of rules. Some of you may not have been here when I went over this earlier today. We've had the benefit of your excellent briefing, and we've been diligently working on your cases. We have several cases today, and each party will be allotted 30 minutes aside if you are opposed, 15 minutes if you are unopposed. If there are more than one attorney on a side, please let me know how you would divide your time at the outset. Also, for the appellant, let me know at the beginning if you would like to reserve time for rebuttal. Also importantly, we really are familiar with the relevant facts and pertinent case law involved in all of your cases. And so we do recommend you focus your time on the more salient issues. And lastly, if your case involves any sensitive topics such as sexual assault or anything else, please refer to children's or parties' names by private identifiers. This is being recorded on YouTube. With that, we will call item number 7367646, Sabrina Crawford versus Wayne County Investment Group Incorporated. And we do have Ben Christensen, attorney Ben Christensen, for a remote oral argument.
Good afternoon.
Just a moment. Let's make sure he's here.
Sure.
All right, can you hear us? Good afternoon. Okay, you may proceed.
Good afternoon, Judge of the Court. Eric Scharf, the Scharf Appellate Group, Miami, Florida, on behalf of Lori Spratt et al. And joining me at council table is Mr. Cooper, the Cooper Law Firm of Troy, Michigan. I appreciate that you're familiar with the briefs. And in this matter, I think broadly speaking, there are two halves in our brief. The first half is the issue of standing. The second half is the merits, which broadly speaking concerns the grant of summary judgment. I intend to focus mostly on the issue of standing. So when we briefed this, we explained that there was a bankruptcy filing. And in that bankruptcy filing, the claims weren't disclosed.
Well, are you talking about the post-entry of final judgment bankruptcy?
Yes, there were actually two bankruptcies that are somewhat relevant to this. There's a 2015 bankruptcy and a I believe it's 2022 or 23. I'm not sure which of those 2 years, but.
Okay, well,
Yes.
let's start with the most obvious problem with arguing standing or mootness. If in fact there's a standing or mootness problem, we dismiss the appeal. You don't get any relief. We just dismiss the appeal and it's over and the judgment stands. Do you really want that?
I don't think the judgment stands.
No,
Your
it
Honor.
it does.
I think you then undertake the analysis under League of Women Voters. At that point, because if that were the case, it would allow every appellee to effectively win on appeal by simply mooting the appeal by destroying jurisdiction.
Well, let's hang on just a second, because if you're going to argue standing is typically determined at the time the case is filed. But here, we don't have a standing problem on the day it's filed or the next day or the next day, all the way through the entry of judgment, standing from literally start to finish in the trial court, right? Yes?
I don't know that that's entirely correct because I think the proceedings may back up. It happens when the matter goes on appeal. If we point this out.
But standing's not determined by where everybody is on appeal. It's determined in the trial court. Mootness can come up on appeal. Standing is something that's a trial court concept.
Yeah, I think it's both trial and
I'm going to
appellate.
disagree with you strongly on that.
Okay. The claim for the appellee to have the ability to represent themselves in this court, they have to have standing to.
They didn't
appear.
bring the appeal, you did. They don't
Yes.
have to have standing. They're just responding to the appeal you brought.
But in order to be able to respond, they have to own the claim. They don't own the claim, the trustee owns the claim. And
Okay,
that-
so wait a minute. Let's take an obvious case. Okay? So let's assume that somebody is seeking to collect on a debt. That's why they filed a lawsuit. On the day that they file the lawsuit, the debt is owed to them. It goes all the way through to judgment. They get a judgment in their favor. The day after they get the judgment in their favor, they turn around and sell it for 50 cents on the dollar to somebody who's going to go out and try to collect it. Within the time, the losing party then appeals of right. Are you telling me that the fact that they sold the debt the next day means that they now lose on appeal because they lost standing? How could that possibly be right?
You're in a situation in which the appellee sells.
The right to
Debt.
collect. They no longer have a right to collect. They've sold it for 50 cents on the dollar. This happens all the time in commercial litigation.
In that case, I would have thought that the purchaser of the debt would then become the party withstanding.
Right.
To
Not the
oppose.
party you're trying to appeal against. It's exactly the same as the situation.
Except there, I think that the party purchasing the debt is analogous in this case to the trustee.
But you're not appealing it. If you're the judgment debtor, you're not appealing against the successor in interest to collect on the judgment.
No, we're appealing as to Crawford.
On the argument that she lost standing after the judgment was entered.
Yes. And
Hey.
I'd also point out that Crawford itself isn't advancing the argument that you've advanced either, Your Honor. That hasn't been briefed at all. When Crawford disputes this issue of standing, she has 3 points that she makes in her brief. The facts are non-record, that her mistake in filling out the form excuses her.
The facts are non-record too. I mean, just to be clear, that she's right about that too.
I would disagree with that, Your Honor. We presented this first to the lower court by motion.
8 months after the judgment was entered, when you'd already appealed and they lost
That's
the
correct.
authority to do anything.
That's correct. And then we also presented it to this court by motion. We presented it at every stage we could to try to avoid this process of briefing. That is correct.
I got it.
Regardless, the facts are judicially noticeable because they are the actions of a sister court, i.e. the bankruptcy court. And we provided copious precedent for the fact that you can take judicial notice of what the bankruptcy court did. And there's no constraint on considering facts of a jurisdictional nature.
But what you're asking really is not to find that anything in error happened in the trial court, but rather to go back nunc pro tunc and invalidate a judgment lawfully entered withstanding to the plaintiff.
I think that's correct, Your Honor, because they no longer have standing to prosecute or to defend this appeal. They lost that when they didn't declare the claims to the bankruptcy trustee and let the bankruptcy trustee substitute in and defend the claim. That's correct. Just to complete my thought, in the briefs, they articulate 3 points: facts not of record, that their mistake in filling out the form excuses the problem, and that the bankruptcy court is the only forum that can consider this. I think I dealt with the facts being not of record. On that point, there's the 3 points: that it was of record by our efforts to put it in front of the trial court, develop that record, and then by motion practice here, judicially noticeable, and that there isn't a record constraint on facts of a jurisdictional nature. That's that. As to the mistake and excuses, 2 points on that: one legal, one factual. Legally, there isn't an exception for mistake. You can't say, well, I made a mistake on the bankruptcy form, so give me a do-over. In fact, that's point blank on the face of the cases that are briefed, Spohn and Young. And factually, if we're going to talk about innocence, sometimes these kind of things implicate messy facts, and the Court of Appeals throws its hand up and says, gee, we can't really decide how big a problem is this? Maybe somebody did make a mistake. The beauty of this is it comes down to a single page, and not even a single page, a single line on a page and a check mark. In fact, I'm holding up the page from the bankruptcy, and it's line 33, and I can read it in the space of 10 seconds here. Claims against third parties, whether or not you have filed a lawsuit or made a demand for payment. Examples: accidents, employment disputes, insurance claims, or rights to sue. And then there's simply a checkbox under that: no or yes, describe each claim. And here it's checked no. And this is, I'm reading off the file stamped record entry document. I brought 5 copies of it. I could hand it to the bailiff and you could look at it if you
Yeah,
need
we've-
to, but I doubt you need to. I'm just trying to make the rhetorical point that sometimes you end up with messy facts and you have to wonder, is there some trick to this? Maybe there is some innocence or some mistake or some ambiguity or something's not quite black and white. There's shades of gray. Sorry, but there's no shades of gray in this form. It's so straightforward. There's no possible innocence or mistake or excuse for this. So getting back to the mistake argument, legally, it's unavailing. Factually, it's unavailing. Lastly, the bankruptcy is the only form to raise this in. Legally, that's wrong because we have plenty of Michigan cases dismissing matters because of failure to disclose claims in bankruptcy, Young and Spone on the face of our briefs alone. So I want to try to, what I've done now is I've addressed the 3 prongs or the 3 parts of Appellee's brief that tried to resurrect or tried to justify why these claims survived bankruptcy. So I want to try to go back and deal further with Judge Yates, your questions about this. You make the point, doesn't this just cause us to lose? Aren't we effectively blowing up our own appeal? An interesting point, one we considered carefully, researched and said, well, what happens if we show that the appellee has no standing and the appeal is moot or lacks jurisdiction because you don't have a party on one side? What happens to us? Fair question. And the answer is found in League of Women Voters. League of Women Voters says, all right, this happens from time to time. An appeal ends up falling apart for lack of jurisdiction, mootness, some problem, jurisdictional in nature arises and the appeal falls apart. What do you do? League of Women Voters is pretty clear. This is a Michigan Supreme Court case, recent. I can't remember the exact date, but I believe it was in 2020s. League of Women Voters is pretty explicit. It says, look to the equities. All right. We briefed this. We said, all right, let's look to the equities. What doctrine would you invoke in this case? Pretty clear cut, unclean hands. Miss Crawford has, as a matter of law, unclean hands. Why? Because it's her inequitable conduct, bankruptcy fraud, failing to do what she should have done, declare the claim that's put us in this position. She has deprived the court of a valid appellee. In that case, what do you do? Where the inequitable conduct of the appellee has destroyed the appeal, is it equitable to let the appellee win? Of course not. That's why what should happen is you should vacate the underlying judgment and remand the matter back to the lower court.
Wouldn't we have to remand the case back to the lower court to vacate the judgment? I'm unaware of a circumstance where we would vacate a final judgment.
Right. Your Honor, as a technical matter, you may be right on that. Maybe that is the exact
Right, we didn't enter the
precise
judgment.
and that may be the precise appellate relief would just be remand with instructions to, or something of that nature, rather than vacate it yourself. I stand corrected.
Okay.
And this gets into some pretty tricky appellate doctrine in cases. In some places, we had to end up drawing from federal precedent and Wright and Miller to try to give examples of how to treat some of these situations because it's so rarefied that this kind of situation even arises under Michigan law. But going back to this point, if you hear this appeal and allow appellee Crawford to have her day in court effectively to oppose us, what you're saying is, okay, you secured a $53,000 judgment that you then wanted to treble to, in round numbers, $160,000.
It was trebled by the jury, right? And then the trial judge took it away.
I think that is technically correct.
I mean, there are a lot of things
Uh,
about this case that I can't even begin to understand. But I think that's what happened with that.
And I'll get to that in a second too, Your Honor, the problem on the second half of it, which is I'll call it summary judgment for lack of a better term, but the unusual proceedings below that led to where we are now, which I can't. Yes, Your Honor, I think that is what happened. I think it was trebled, then untrebled, and then they wanted then to treble it again on cross appeal. I believe the cross appeal has been abandoned.
Yes, we looked very carefully at that.
I appreciate you saying that, but as did we. There's been no brief filed on it. It hasn't been dismissed though, which leaves me a little queasy on that point that it's going to be raised at oral argument, but I believe it's been abandoned. So that deals with the bankruptcy and lack of standing. To allow this to proceed with on the theory that there is still standing is to reward somebody for taking this amount of judicial relief, not telling a bankruptcy trustee, oh, by the way, I've got in round numbers, something around a $200,000 claim floating out here in state court. Discharge all her debts, then show back up, take the house, take the $53,000 judgment, try to treble it, have walked away from all her creditors and hold in her hands. I see you.
But isn't the victim of that or the victims of that the unsecured creditors in the bankruptcy, not your client?
The most direct victims are, you're right, Your Honor.
Like they're the only ones. Because if she obtained the judgment and she didn't disclose the judgment, didn't disclose the ownership of the property, didn't disclose any of that, the consequence would be that maybe the secured creditors, but much more likely the unsecured creditors would get stiffed, right?
That is correct, Your Honor. I would point out, however, that this is a rolling pattern of this that continued from 2015 to 2022.
Right.
And
there's so many, I think your client filed for bankruptcy too. I think there've been so many bankruptcies. We had a heck of a time just trying to figure out who filed when.
I can understand your confusion. I shared it when I was working on the briefs. In 2015, however, even representations were made by Ms. Crawford as to the status of the house. And it was not that she had a quitclaim deed to it. It was just the exact opposite. And yet then in the trial, the claim was the opposite. That goes to the second half of this, which I think I want to try to get into now. On the back half of this argument, it concerns the proceedings and how we arrived at where we are now. It is a nominally summary judgment, and yet the proceedings are unrecognizable under Michigan law. It was denominated summary judgment, and yet there is an evidentiary hearing. The evidentiary hearing has limitations which are
Well,
bizarre.
hold on just a second, because
Sure.
I want to try to characterize it as best as I see it. Plaintiff had claims for money damages, which could and did go to the jury. And then she had an equitable claim dealing with the property itself, right? The quiet title request. Yes.
I don't know if it's exactly correctly characterized as a quiet title test, and I don't want to admit that.
Okay,
I would give you this. It was a claim to get the house somehow.
Correct.
If you want to call it quiet title for simplicity's sake, I can understand why you would call it that. I don't know that that's exactly what it was.
Right, but let's not worry about that. I
I
mean,
think it might have been specific performance might have also been the way.
right, but it's an equitable claim, and so it can't go to the jury. In other words, the trial court has to deal with it as the trial court, not have a jury do
The
it.
getting the house has to be equitable one way there, whether it's
Right,
quiet
whatever the
title or
claim is.
specific performance. I would agree with that.
Right, and so the way I think I see this is instead of having one consolidated trial where the jury would have been completely baffled by what in the heck was going on about this whole argument about quiet title, the trial court effectively bifurcated and said, I'll take the equitable issues, I'll clean those up. The jury will deal with the request for money damages and they'll take care of that.
That would be a recognized procedure, of course, because you can't have a bifurcated procedure. You can have a bench trial and a jury trial. But that really wasn't what this was. I mean, this was the court was purporting to hold a hearing on summary judgment that morphed into an evidentiary hearing or
But where did your client object to the evidentiary hearing? I mean, one of the things about a lot of the arguments in this brief is there's no discussion about preservation. There's no discussion about what the standard of review is. You just sort of jump into the arguments and start making them. And I've got real preservation problems here.
One thing I'd point out globally on the issue of preservation is, to the extent the court's suggesting that we may have waived any of this.
Not waived, just, or told us. Told Oil says if you don't assert a claim, it's gone. An argument, an issue, whatever, in civil cases.
I would point out, however, that at the appellate process, waiver itself is subject to waiver. And
But
the
this is the
appellee-
waiver. It's not the knowing relinquishment of a right.
All right, but the argument of preservation wasn't advanced by the appellee either in their bottom side brief here. Is one point I would make. Another point I would make is, I believe we did object at times throughout the evidentiary hearing to the limitations imposed on it. And in particular, the single worst aspect of the limitations, the inability to call the ex-husband.
But okay, stop for a minute again. Your client never identified the ex-husband as a witness. The other side did. And so they might have an argument, but over and over again, they would list the ex-husband as one of their witnesses. Your client never did that.
I think I think probably based on the fact that he was already identified with the other side, we expected to call him. The centrality of his testimony is simple. The claim is by Miss Crawford, I'm living in the house, I'm making payments, and now I want Miss Spratt to convey title to me outright. Why? Because I bought it under a land contract that I then somehow paid off $5,000 to who? To Leonard Spratt, my ex-husband.
Well, it was $3,000. The $5,000 was down. The $3,000 was the back end of it. It was the money that came out of the district court proceeding.
I stand corrected. She made a lump sum cash payment at some point.
$3,000.
And there comes questioning, do you have a receipt or proof that you made this payment? No, it was cash. Would have liked to examine the ex-husband on this point. He can't even.
I just wanted to let you know you're hitting about the 9-minute mark, so just in case you aren't.
I need to wrap up quickly then.
Yes.
Regardless, the inability to call that person and just even ask him what level of proof is that this payment was even made, because of course they're getting
Exhibit
divorced.
4 at the hearing was a receipt that said paid in full. Yes?
I honestly, Your Honor, I don't remember that.
Right at it.
But, okay, but regardless, our client didn't get that money that would have gone to the ex-husband, who has every incentive to go around effectively selling the property, which he's then going to be forced to turn over during the divorce. That's ugly, to say the least. The three arguments against the summary judgment point is it's discretionary to hold an evidentiary hearing on summary judgment. I point out it's not. You can't resolve disputed issues of fact by holding an evidence. Yes, I don't need to belabor that it's harmless error. No, we don't have a protocol for harmless error analysis for deciding summary judgment. We decide whether there's a disputed material fact. The witness testimony is discretionary. I mean, that's true to a certain extent, but not when it's the central witness that needs to bear witness to the core part of the test of the core part of the transaction. So the errors here that went on in the proceedings below were considerable. We've outlined them. I need to wrap up if we're going to have 5 minutes for rebuttal. So I'm going to do that. Thank you for your attention.
All right, counsel, you may proceed.
Good morning or good afternoon, Your Honors. May it please the court, Ben Christensen on behalf of appellee in this matter. Your Honors, the core issues we believe are straightforward. The standing and bankruptcy argument was never raised below, and it relies entirely on materials outside of the record.
In fairness, though, they couldn't have raised it below because everything that happened that was the predicate for the argument was months after entry of judgment, right?
that's true. But as a court of review, this court cannot consider, the issue on the first time on appeal. And as to the remaining issues, the hearing appellant challenges was simply the court's chosen way to resolve the competing motions for summary disposition.
Wait, are you talking now about the equitable interest in the property?
Let me see,
Because somebody owned the property and somebody didn't, right?
right. There was a
Are you talking
determination
about the
of,
hearing that took place on that?
yes, let me see, quiet title litigation, which would have been.
Because I'm not sure that you can have an evidentiary hearing on summary disposition, but I'm also not sure that the trial court was granting summary disposition. I think it was just essentially a streamlined bench trial, for want of a better word.
And and I think that's that's in line with our point. It's call it what you will, but the court was trying to wrangle a lot of difficult parties and difficult issues and tried to make it into something that made sense and was fair to both sides.
Right, but is that allowed under the court rule? I mean, maybe they think that you should just shoot free throws to see who gets the property. I mean, that's not allowed under the court rules.
No, but I think
that say it was a way to try to solve the problem.
I think Your Honor, that the judge took the best approach that was available to her to ensure fairness. There was sworn testimony on each side, documentary evidence provided, the 36th District Court's judgment, deed, admissions, receipts. There was they had every opportunity to support their own motion and their competing motions, and the judge, I think, addressed it in the quickest and fairest way possible, given a very complex issue.
Okay.
The trial court. So even if the court sees anything unconventional in the process, as we've argued, it is harmless at most. And unless the court has any further questions, we're content to rest in our briefs and address any point the court would like clarified.
Okay, thank you, counsel. We have no questions. Thank you for your argument.
Thank you. You bet. Thank you.
Proceed.
Yes. In the interim, I've been trying to struggle with the hypothetical you posed about the debtor or the
judgment
who sells in the interim
judgment
of the appeal. And I wish I were quicker on my feet enough to figure this situation out. I think there is probably a principal distinction to be made between selling a cause of action or selling a right and declaring bankruptcy, where you are having to go through a judicially administered process and sign things under oath and perjury and taking advantage of public proceedings to discharge debt.
It's a 5-year felony to lie on a bankruptcy schedule.
I've been trying to avoid using those terms to let proceedings be a little bit less charged and loaded. But yes, it is. And I don't have I'm not a prosecutor.
I was a federal prosecutor,
Yes,
so I happen to know what the penalty is.
And I can't dispute that. But it's a problem. I think that at minimum, there's a public policy consideration that's present in the bankruptcy scenario that's not in the commercial transaction where you're selling paper, like selling an instrument in the middle of an appeal. In the selling situation, at minimum, there's always going to be a chain of somebody who has standing to argue on behalf of the instrument or debt. In the bankruptcy, It's a judicial process of handing a baton between one party and the other, where the debtor is sick, is going into court and saying, can't pay my debts. Mr. Trustee, here's everything. You take over, Mr. Trustee, and I'm putting you in my hands. And you have to give them everything. And the whole point of this form I'm holding up, which again is the one page that is saying, here's everything. You decide what to do with it. And by not telling them, here's a bunch of stuff out there to do with it, you're really interfering in that process in a way that is incredibly pernicious, which is why, of course, we assign a 5-year penalty to that and a felony.
Agreed. I mean, if you fail to disclose $1 million mansion, that's a huge problem. I mean, I'm not saying this is $1 million mansion, but same thing, matter of degree, not kind.
I've taken court-appointed cases under the Criminal Justice Act of the Sixth Circuit, where I was a law clerk, where I represented somebody in a bankruptcy fraud claim, where the claim for defrauding was solely not showing that they had an option to repurchase some minor interest in land that couldn't be exercised because it was worthless. I mean, it was so trivially worthless as to be a joke, and they were popped for bankruptcy fraud. And he's a white collar executive, and that dude went away for the better part of 2 years, destroyed his life and family. And the value of that thing was less than a postage stamp. It couldn't have been exercised because there's no money to exit. I get off topic here because I'm really, you pose some excellent intellectual challenges with this issue of what happens when you blow up appellate jurisdiction in the middle of an appeal and you're the appellant and you want the Court of Appeals to decide something, and it's the appellee whose inequitable conduct you're charging is having destroyed the appellate jurisdiction. What do? I keep going back to League of Women Voters and the concept of you remand with instructions to vacate. Now, as to whether there could be further proceedings below to continue enforcing this, I suppose there could, but that's then going to run into the problem of the lack of standing in front of the lower court as well, I suspect. But that's for another day. Trying to go back and struggle with this hypothetical of the debtor selling something, maybe I've dealt with that enough. Trying to go back also to the proceedings, the second half of this whole thing. The idea of this being a streamlined bench trial, could the judge have held a bench trial on issues of either specific performance or quiet title? I'm sure that is a valid procedure under Michigan procedure. That's not what was done here. This was purporting to be summary judgment. It's like an augmented summary judgment in which the judge held an evidentiary hearing to resolve disputed issues of material fact. That hybrid procedure is not cognizable under Michigan law, especially not when you hold a limitation that I'm only going to hear testimony from the plaintiff and the defendant. There were other critical errors. The only testimony supporting the plaintiff's claims was from Ms. Crawford. It directly contradicted her 2015 sworn testimony about the house.
2-minute warning.
Yes, thank you, Your Honor. In 2015, she averred in her bankruptcy filing, this is the deal with the house. Not that I have a quitclaim deed to it. Again, the deal was the underlying transaction is so flaky that she claims to have gotten a quitclaim deed in 2014 from the ex-husband by paying, as Judge Yates corrected me, I guess, $3,000 cash, and then waiting 4 years to record the title to 2018. So her testimony is already verging on the fantastical. When you combine that with the fact that directly contradicts her 2015 bankruptcy filing, in which she again did not declare that what she's then testifying to in the trial, that leaves no valid evidentiary basis for any of the judgment, because it would have to travel through her testimony at the whatever this proceeding, whatever we want to call it. That's the sole basis. It all hinges on her testimony of, yeah, I paid $3,000. I had this land contract. I paid $3,000. Not the same as what she averred under oath in her 2015 filing. And we've cited cases, you can't have directly contradictory testimony. It's perjury by inconsistent statements is often how that's phrased. So summarizing, the base problem is standing, mootness, however you want to term it. The problem is the one checkbox doesn't say, doesn't disclose these claims. And I went through all the three reasons dispelling them in the brief. If you look at the proceedings, they are not cognizable under Michigan law. The matter should be reversed.
Thank you.
Thank you very much for your attention to this matter.
Thank you. That matter will be submitted. Calling item number 8-368-756, Johnny McPherson versus Alton Homes Incorporated. Good afternoon. You may
Good
begin.
afternoon. My name is Sean Serafini. I represent appellant Johnny McPherson in this appeal from the Wayne County Circuit Court. I'd like to reserve 5 minutes of my time for rebuttal.
Okay, thank you.
I know the court's read everything, as I can tell by the prior cases that I just listened to. So I won't go through the facts of this case. However, I recognize that they are, I should say there are a lot of moving parts to the underlying facts that that are inherent to this appeal. So if the court has any questions on what happened at the trial court level, either in this case or in the other referenced case, please feel free to let me know. I have fully prepared to discuss that. Jumping into the issues, there are two primary issues in this appeal. First, that the trial court judge, Judge Heisey, erred in finding that appellee Alton Homes, a closely held corporation, could not be sued after suit had been dismissed against the principal of the corporation, Alvin Sallin, in his individual capacity for the reason that he was the wrong party to sue. Integral to this determination was her erroneous finding that Alton Homes and Alvin Sallin were in privity with each other, such that they shared identical liabilities and obligations. And this is especially pronounced when the prior suit against Alvin Sallin had only been dismissed because the trial court found that Mr. Sallin could not be held individually liable for Alton Homes obligations and liabilities.
Let's stop there for just a second, because I think summary disposition was granted under C7, right?
You're talking about in the Alvin Sallin case, or this Alton Homes?
The second case, not the first one.
The Alton Homes matter, it was granted under C7
Right,
for
in
res
the-
judicata
Right,
reasons.
right. But that would be a C7 grant, because the initial grant was you sued the wrong person. This individual has no relationship to the property that's a basis for liability, right? Which sounds to me like a C10 grant.
Correct, that was a C10 grant.
Okay.
Highlighted by the fact that the trial court
Right, but
initially denied the motion.
But you're not challenging the original grant of summary disposition in the first case, right? So we don't have to worry about the C10 grant. We just have to worry about the implications of it, right?
Correct, Your Honor. And that's an important point because by the time that this issue reared its head in
Hold
the
on,
Alton Homes
right,
case.
because I want to pin down exactly what the standard review is. So what you're complaining about is the second case, the grant of summary disposition under C7, right?
I believe it was granted under C7 and C10, but for the same
Okay,
reasons.
but then there was a motion for reconsideration, right?
Correct.
Okay, now, this is a big buildup to a fairly simple question. Is our review de novo as it would be for a summary disposition grant under C7? Or is it abuse of discretion as it would be in denial of a motion for reconsideration? Or is it both?
Since the motion was granted for C7 and C10 reasons, this court reviews the decision to grant a motion for summary disposition de novo.
Okay, but the final determination was a denial of reconsideration, which is abuse of discretion. Your position is, and I think you're probably right about this, but I'm going to give you each a chance to weigh in on it because it makes a difference whether it's de novo or abuse of discretion. Your view is what we're really looking at is the C7 grant, not so much the motion for reconsideration now, right?
That's correct, Your Honor.
Just wanted to be
That's
sure.
absolutely correct. And that is an important point. So this is we're only seeking review of reconsideration, I guess, to the extent that it's been argued that you can't ask for reconsideration after the trial court has completely issued a new order. You can't ask for that order to be reconsidered because reconsideration was what led to that.
Okay, I'm sorry to slow you up. So let's
That's
let's
perfectly fine, Your Honor.
let's get to the race judicata.
Okay. So the first issue is that what I went over, that there was a prior case involving Alvin Sallin, dismissed because Alvin Sallin could not be sued individually. Second case, Alton Homes, his closely held corporation. Trial court initially rules that Alton Homes is not in privity with Alvin Sallin for purposes of this case, and therefore suit can proceed against Alton Homes. On reconsideration, that was with Judge Leslie Kim Smith, who heard the original motion for summary disposition in the Alvin Sallin case. She then gets promoted to chief judge in Wayne County, and a lot of her docket gets reassigned to Judge Catherine Heisey. Reconsideration is filed, so 8 days. It was filed 8 days after Judge Smith's order. Judge Heisey subsequently takes over in February.
Counsel,
A few days later.
we're really familiar with the procedural
Okay.
history, so just go right to your argument.
Right. If you don't mind, talk about Wild Fawn. Or
Wild Fong, yes. So Wild Fong recognizes an exception to the general rule established by the Supreme Court that corporations, even closely held corporations, are separate and distinct from the individuals that maybe the sole shareholder of that corporation, maybe the principal, it doesn't matter. They're separate and distinct from their principals. Wild Fong recognized an exception to that rule for the express purpose of presenting an injustice, a double recovery. In that case, the plaintiff's corporation, their closely held corporation, it was a family-owned corporation, had sued and already recovered against the defendant. Then the Wild Fong case specifically dealt with the individuals that owned the corporation, the family, suing the same defendant. And the court said, true, we do recognize that usually you are separate and distinct and you can bring your own causes of action. However, here we face the issue of a potential double recovery, and therefore we are not going to allow that inequity to take place. We are going to invoke the exception to the rule, which is that we are going to treat you as one and the same. The family and the corporation is one and the same. That does not apply here. That is first of all, a one-off circumstance. It's only been used in that type of situation, and that's not the situation that we face here. Alton Homes does not face a double recovery. Alton Homes is trying to offensively invoke this rule to escape any liability whatsoever.
I don't mean to cut you off, but isn't there a difference between plaintiffs and defendants when it comes to substantial identity of interests? If you have plaintiffs like in Wild Fong, you actually have the potential for double recovery. When you have multiple defendants, you don't have that problem. Yes?
I think that's completely true. I don't think there was ever a risk of a double recovery in this situation where you just follow the standard rule. And that's exactly my point, Your Honor, is that this rule is supposed to be invoked in a specific particular situation. It is not supposed to be invoked by a party trying to use it essentially to avoid any liability whatsoever, merely because of a technicality that arises out of older case law, dicta from older case law, and just inherent unnatural things that arise from the corporate form, since it is a fiction of law.
And as
So-
luck would have it, we've said that very same thing in 2 unpublished opinions. We just haven't said it in a published opinion yet.
Very well, Your Honor. It seems we may be on the same page on this particular issue. So that is the scenario with Wild Fong. Judge Heisey followed Wild Fong's exception, or I should say she applied Wild Fong's exception. She treated it as binding, that she had to follow the Wild Fong exception. I think that is incorrect on a factual level, as I've detailed. I also think it's incorrect on a procedural level, since the opinion was issued in 1989. Therefore, it is not binding, since it was not issued after 1990 pursuant to MCR 7.215J.
You're not saying we need to disregard it and go the other way, are you? I mean, I think Wild Fong is so obviously distinguishable from this case.
No, I'm not saying that at all. And in fact, Your Honor, as you probably read in my brief, I actually think that Wild Fong supports our position in this case. It supports the fact that equity concerns, only where equity concerns are invoked, significant equity concerns, that the exception should be applied, and they're not invoked here. This is a case where the standard rule should be used. The standard rule where corporations are treated separately from the individual. And that's what we are dealing with here, not a special circumstance. My only reason to point that out was that Judge Heisey felt like her hands were tied. I think it was, I think she misinterpreted the case, but nevertheless, it is not a binding case.
Well, it's binding on trial courts. It's not binding on us. It's a
That's
weird
correct.
distinction, but it matters.
Yes, that's correct. It is found in the appellate portion of the tort rules, and it does say that. Regardless, I'm getting a little bit far afield on this issue. I
think you're in good shape.
Appreciate it, Your Honor. I think Wild Fong supports our position, like I said. I won't point out my catch-22 scenario that I detail in the brief and go through that. But to hold that Alton Homes is in privity with Alvin Salen here, and to go through that whole scenario in light of the prior order creates a catch-22 scenario that's completely illogical and inescapable. And it's the exact type of thing that these rules are designed to prevent. The standard rule and judicial estoppel. As to James White and James White Enterprises, LLC, I'll collectively refer to them as James White for purposes of this argument. That's a subsidiary issue that derives from the original determination that Alton should be dismissed, which I believe is an error. However, there are other findings of fact associated with that determination that are also problematic. Namely that James White, a random contractor hired by Alton Homes to install the railing at issue, is in privity with Alton Homes. There was no factual undertaking to determine that was actually the case. Judge Heisey summarily concluded that, and I'm paraphrasing here, but not by a lot. She said that it was for purposes to allow this case to go up on appeal so that it could be decided by the Court of Appeals because the case was in a terrible snarly. And that last phrase is a direct quote. I think she recognized that it was not a fully fledged out issue.
For what it's worth, I don't know how in the world anybody could argue that there's privity between Salen and these complete separate entities. I mean, I read it over a couple times just to try to make sure that was actually the basis for the ruling.
I totally agree, Your Honor. In all respect to Judge Heisey, I do think that her reason for ruling that way was so that the entire case could just go up on appeal all at once. I think she had good intentions to have it all decided as a whole. But I do agree it's a totally erroneous finding. My only other point as to James White is that res judicata cannot apply within a case. That was the other reason for their dismissal, was that Alton had been dismissed as a co-defendant in the same case. Obviously, res judicata needs a final order that it can attach to. There's no final order. And
that sounds quite familiar to something that came up about 2 cases earlier today.
It does. And I thought to the time I should write that down. I said, I think I already have it written down. But there's no final order here, so it can't apply in that situation. So it was based on privity and res judicata. Both of those bases were an error. If the panel has any further questions, I will be happy to entertain them. Otherwise, I will reserve my time for rebuttal.
All right. Thank you, counsel. We have no further questions.
Thank you.
Thank you for your argument. All right.
Good morning, Your Honors.
Good
My name
morning.
is John Kaplansky, and I'm here on behalf of the defendant.
It's an uphill climb, Mr. Kaplansky.
Well,
But go ahead, give us your best shot.
I will do that. I don't think it's quite as messy as they're trying to make it out to be. The major considerations here, from my perspective, is that whatever the problems the plaintiff has in this case, they created. I had nothing to do with it. The next thing to be considered by the court is that a court speaks to its written orders, judgments, rulings. And the last consideration is that the case is dominated by the Michigan court rules, which all young lawyers should know and really get into the depth of them. I was taught that when I was a young lawyer. The older guys, which I guess I became one, they taught it to me, and now I pass it down to the younger ones. The facts are fairly simple. Mr. McGuire rented a house from Alton Homes, and there was a written lease, and he lived there for 6 years, during which time Mr. White was the handyman who came and fixed things.
Sorry, I don't mean to cut you off, but getting right into the legal argument, can you provide the rationale for the prior suit was dismissed because the court held that Salin was not the right party, that he did not have a legal obligation or responsibility that he could be held liable for this incident. How then does that carry over to the privity argument in this case?
She didn't exactly say he wasn't the right party. She said, I mean, that may be a conclusion, but what she said is he's a shareholder. The shareholder and the corporation are separate, and he was not the possessor of the
Right, so
controller.
he couldn't be the
therefore
legal
don't. Okay.
entity that was.
So, and your question is, how did that carry over to this case? So this case is two defendants, Alton Homes and White. White's nothing but a handyman. And Alton Homes, the real issue is the issue that how this arose is defense filed a motion on the grounds that res judicata applied for the reason that 2.504 said that the ruling was, it became a ruling on the merits. The issues were the same, the facts and circumstances were the same, and the parties were the same. So
Parties were not the same. I mean, I understand your argument under Wilfong,
parties
but
or the privies were the same. So now we get into privies.
Right.
So now we get into privity. And the issue was brought in front of the first judge, and she ruled that the actions were decided on the matter. The matter in the second case could have been decided in the first case, but she said, but there's no privity because there's no privity between the sole shareholder of a corporation and his corporation. Now, we raised Wildfong in the first case. However, I didn't really argue Wildfong for the reason that, in my view, a sole shareholder and his corporation, they're joined at the hip. They're absolutely in privity. You can't make anything that actually creates more privity than that. And the criteria for privity.
a lot of corporate entities would disagree with you. The whole point of a corporate entity is to have a legal distinction between even if it's a singly held corporation and the corporate entity, like that is its own legal.
Well, that's confusing. The corporate veil, because a sole shareholder.
Like there are very specific
But
reasons.
privity is a different thing. Privity is part of res judicata. So you have res judicata on one hand, and you have the corporations on the other hand. For purposes of privity, that goes into res judicata. And that is, do the folks involved, and this is what Wildfong talked about, do the people involved have the right to make decisions, have the right to participate in
the
and
things
how
with
it's
legal
going to come out. And that's
obligations,
what
right?
Wild Fall's all about.
One of the things with legal obligations and liabilities,
I'm sorry.
legal obligations and liabilities. That was one of the considerations in Wildfont, correct?
A shareholder has a right to protect his corporation. There's no real issue about that. They have the right to participate. They're involved in it. And when you get into White now, you have the main parties involved are Salin, that's the first decision. Then you have Alton, who really should have been part of the first case, and they're not, so they were dismissed. And White. So you got the three entities who were involved in this thing. It's like three folks in a foxhole. They're all there for the same, they all got the same interest. There's no separation of the interest. They are all defending themselves. That's what they're doing, and that's the criteria for establishing privity. In my mind, it's not a difficult concept, and I can't imagine that the sole shareholder of a corporation doesn't have the obligation to defend his corporation. It just doesn't make sense. And Wildfong is not an outlier. Wildfong became the basis for several other cases that raised it. The difference in Wildfong.
But Wildfong involves plaintiffs.
Right.
This case involves defendants.
Right.
And we've already said in two unpublished opinions, that's a huge difference and it's dispositive. That's why Wildfong doesn't apply when you're talking about privity for defendants.
That doesn't.
Because
With all due
we said it
respect,
twice.
with all due respect, it doesn't make sense.
Sure it does,
It's
because
the same concept, except there's no reason why defendants can't use the same concept as the plaintiff. As a matter of fact, most cases where res judicata is applied is because a plaintiff should have brought the case. A plaintiff should have brought the case. Okay, Wildfong is first the corporation brings the case, then the individuals bring the case. And in this case, first the individual defendant is the defendant.
Right.
But the corporation should have been the defendant also, so should White. He should have been
Right.
the
But
defendant.
there's a world of difference between the two. If you have multiple plaintiffs, you have a very reasonable likelihood of double recovery. When you have multiple defendants, the worst that's going to happen is joint and several liability. It's not like a single plaintiff's going to be able to recover damages twice.
There's no legitimate reason for the same concept of privity to be used as a defense.
But why have we said that twice before then? Are we just crazy? I mean, we haven't said it in a published decision. Look, I don't think a single one of us is on either one of those panels, but I mean, it's pretty obvious.
What I'm trying to get at is there's no reason, there's no legitimate, as I see it, there's no legitimate reason for the same concept of privity to be to be available to a defendant as it would be to a plaintiff. It just doesn't, in my mind, it just doesn't make sense. And I think and the same thing happens with respect to White. If Alton is entitled to res judicata on the grounds that it's the same case and there is privity, then White, he's part of it too. He should have been part of the first case also.
Wait, the contractor can't possibly be in privity with the sole shareholder of a closely held corporation, not on any planet.
For a different reason, because they all, remember three guys in a foxhole?
Right, but
They all have the same obligation to defend. They all have the same right to defend.
That's not res judicata. That is, if anything, mandatory joinder. It's not res judicata. It's a joinder problem, if anything.
That's not a joinder issue. I don't see it as a joinder issue. They had the opportunity to join.
Wait, you gotta let me talk. How in the world can a contractor brought in to the property in an arm's length relationship with the property owner, whether it's the individual or the corporation, be in privity with the individual or the owner of the corporation? I can't even begin to fathom how that argument could ever work as a matter of res judicata. There's just no privity at all.
The contract creates the relationship between the owner of the property and the contractor. The contractor is in privity with respect to a suit brought by the premises owner. And even if you take White out of it, White's a handyman. But there's no doubt that there's no doubt that Alton is in privity with the shareholder. And any ruling that is contrary to that, in my brain, is inconsistent with what I understand the criteria for privity to be. And there are a lot of cases that talk about what establishes privity. And I don't see how legally the court can separate a sole shareholder, not like a public corporation, but a sole shareholder from his corporation. I mean, there's a lot of, attorneys out there that are, sole shareholders of their PC. And to say that they're not in privity with the PC is to say that, I want to use an example. And
So it has to do with the size of the corporation, a corporation like
well,
a very large corporation.
They have a difference, but I don't think it's that much different from husband and wife, because you're gonna hear a lot of lawyers say they're married to their PC. So to borrow that. Okay, and to not include privity, or to not say there's privity, I believe is inconsistent with Wild Fong. Okay, and I do believe Wild Fong applies to defendants as much as it applies to plaintiffs. And my last observation, if I were to get beyond this, is that, there's an equity issue here too. When the second lawsuit was filed, they blew the statute of limitations. The only reason that it is within the statute of limitations is because of the COVID extension. And they made that by 9 days. The other aspect of it is they sat on the case for a year, actually 14 months. And they didn't wake up until I filed a motion for summary disposition to get Salem out of the case. They have no equity here. So if
Right, but res judicata is not an equitable concept. Res judicata is not an equitable concept.
I'm not saying it is.
Okay,
What I'm saying is they don't have equity here before this Court of Appeals. Because
so they can't win on the res judicata argument because there's no equity here.
Well, no, the res judicata issue, I think is a matter of law.
Yes.
To apply. As a matter of law as a matter of law to say that the same equity issue, privity, does not apply to defendants, I think is error.
Okay.
As a matter of law. And I'm getting the impression you folks disagree with me, but maybe not. Yes, I have nothing further. Everything else, I rely on the brief, and I still say that there's absolutely privity between Salon and his corporation.
Right. Thank you, counsel. Appreciate your argument. Rebuttal? You may proceed. You're welcome.
Just briefly, the Supreme Court in Adair v. State said that for privity to exist, you must share identical legal obligations and liabilities. That's just not the case here. If a sole shareholder of a closely held corporation shared identical liabilities and obligations, they may share some interests, but if they shared identical liabilities and obligations, there'd be no reason to set up a corporation in the first place. In fact, in the Alvin Salon case, that's explicitly what he argued, was that he could not be held liable for the debts and obligations of the corporation. As to defendants White, the claims are just totally different. The claim against Alton is based on statute, the Landlord Tenant Act. The claim against defendants White is based on just general negligence and premises liability concerns. So their defenses are totally separate. Further, they're sort of at odds, pointing the finger at each other to some extent, as I detailed in my brief. As to res judicata, and this is what I'll conclude on, I do agree it is a matter of law. And the law says that you only deviate from the normal rule if there are special equity concerns about double recovery, such as in Wild Fund. We don't face that situation here. Therefore, I would ask this court to grant the relief requested.
Okay. Thank you, counsel. Great argument as well. You both have a wonderful day. Goodbye. You're welcome. All right. That matter will be submitted. Calling our last matter on the docket today, 369. I'll stand up before, yeah. I'm calling, case, item number 369-413, Phase One Rehab LLC versus Allstate, Property and Casualty. You may proceed. I'm just gonna stand for a second.
Good morning, or
Good-
good
Good
afternoon, Your Honors.
afternoon.
Gerald
Um,
Palovich on behalf of the plaintiff appellant, Phase One Rehab LLC. I'd like to reserve 5 minutes for rebuttal, but for the most part, I was just planning on relying on my brief. There's a couple things I wanted to note with the defendant's brief and the exhibits they attached. Just to point out to the court, their exhibits B and C were not actually part of the lower court record. So B is an email from defense counsel, just basically stating some conditions to Sierra Riley's counsel before there'd be a settlement as part of a facilitation back in June of 2022. And then Exhibit C is a copy of the ultimate release agreement, which wasn't actually executed until September 1st. So I don't know why they chose to append those, but that's the trial court didn't have those.
Right. Your point is it's nowhere in the lower court record. It has no business being in front of us.
That's correct. I wouldn't mind it being in front of you because I think it actually furthers our argument, but I won't waste the court's time on that. I'm sure you can't see it from here, but that only leaves in terms of the evidence that was submitted by defendant in this case in the lower court. It's our Bates 105. It's just a list of dates and payment amounts, and you can see the big black lines here probably.
Yes.
They didn't say who they paid or what they were paying for, but we would recognize that it does add up to the 250,000. However, it is worth noting as well, all these payments were after my client had already submitted a claim and made a claim. So this was the evidentiary record that was actually in front of the court. And the MSD was filed very early on in the case. So, our response was essentially, okay, this was after we submitted a claim. All these payments were after we submitted a claim. And we don't know what this list actually is. We don't know what these payments were for. We don't know if it's actually allowable expenses. It's a list that adds up to 250,000.
Right. It's not a question of whether they just get to 250,000. It's whether they get to 250,000 by treating the claims in chronological order and making sure that they're compensable and all of that. That's the problem with this $250,000 cap. It's just, it's a race to try to get the little pot of gold now.
Right. And there's some different ways to that the court could try to fill the gap that the legislature left. But in this case, the court probably doesn't need to get there quite yet. I mean, there wasn't sufficient evidence submitted to the trial court to rule in defendant's favor on that issue. With that, I mean, I'll reserve some time for rebuttal unless your honors have any questions.
Oh, thank you.
Thank you.
Good afternoon, judges. Nick Gamber on behalf of defendant and appellee. And I will also try to be brief, and it's been quite a long day. But I want to first point out that the lower court did not decide this on a exhaustion of the MACP cap. It decided it under 3112.
Right.
And so the issue of the release that came up, it was first, and it was submitted to seal to this court. It was a confidential release. There was a companion case that was with Judge Coretti and Mr. Polovich's firm, in which we did provide the release, and we made the argument that that release exhausted or relieved.
Brought up in the reply brief, correct?
It was brought up without the release, but yes, it was brought up, and that was to illustrate that no, these were redacted. These payments because of the confidential release. It was not just, I'm trying to pull one over on plaintiff's
What about
counsel.
the documents that were submitted to us that may not have been in the lower court record?
That was in front of Judge Coretti on a Michigan ambulatory case. Judge Coretti could take notice. He doesn't have to turn his eyes away and pretend that he doesn't know about the release. We did bring an exhaustion MSD. However, Judge Coretti ruled that it was under 3112, that these amounts were discharged, that Allstate was relieved of its liability. And so and that's because plaintiff in its response in the phase one case said the proper way would have been for a motion for equitable apportionment under 3112. Judge Coretti looked at 3112, took judicial notice of the confidential release and said, no, this was made in good faith to a party, Sierra Riley, who Allstate believed was responsible for payment to phase one. That release, which is also with you, had a non-exhaustive list of medical providers. And so that non-exhaustive list, which never excluded phase one. In fact, we didn't know about phase one until about 3 weeks after the facilitation and the agreement was placed. It would have encompassed. And so the reply said, you have to go to Sierra Riley. She agreed to this. 3112 does give a medical provider a direct cause of action, but it doesn't give them the exclusive cause of action against an insurance company.
Right. They're just another claimant like everybody else.
Exactly.
They don't even have to take assignments anymore. They can bring their own action and
But at the
fight it out with everybody else.
correct, Judge. And at the time we settled, and even holding aside when the release was executed, because it was executed September 1st, after we got the notice, but there was no assignment. And that's where physiatry comes into play, because without that assignment, Sierra Riley had a right to claim those bills and did claim those bills and release them. And so not until phase one brings suit in January of 2023 is Allstate ever put on notice there's an exclusive right to these bills that was granted by her to phase one. By that time, we have already executed the release. It says this is for all past, present, and future benefits. And at that time, we then exhaust the cap. A few months later, we bring our motion for summary disposition, arguing it's exhausted. And then Judge Coretti, who has the release on another case, and the release was with appellant's counsel, says under 3112, this is exhausted. And he made the correct ruling. As to the exhaustion defense, I don't believe we get there. I'm happy to answer some questions regarding that, but I really do believe Judge Coretti correctly analyzed MCL 500-3112, found that Allstate made a good faith payment and exhausted or divested itself of any liability.
Right. So in your view, this is nothing but a simple, straightforward question of double recovery.
Correct,
You
Judge.
thought you paid it off and now here comes somebody else with their hand out.
Correct. We had gone through, we had revoked the assignments. That's what the holdup was. We were revoking all these assignments, trying to make sure that everything was encapsulated in the settlement for Miss Riley. The other providers who had suits at that time were excluded. And then, as you said, Judge Yates, someone else comes with their hand up and we say, sorry, you have to go to Miss Riley, who has taken on the responsibility for paying this. Unless there are any other questions?
Okay, no further questions.
you
Thank
very
you,
much.
counsel. Thank you for your argument. Rebuttal?
Yes. So on one hand, they're saying Riley had a right to claim phase one's bills and they thought they paid it. And then on the other hand, they're saying they didn't have knowledge of phase one's bills.
Right.
So they can't have it both ways there. And in terms of what Judge Coretti was relying upon and whether he was even aware of the release being part of the record in the Michigan ambulatory case, which wasn't appealed. I don't think that we can make that assumption, because in his order on defendant's motion for summary disposition. That he's basically stated that there was a facilitation in June and Allstate paid out the whole 250, the whole list of payments from September of 2022 to March of 2023 based upon an agreement made at that facilitation. And that's just not actually what happened. We have to actually get into the exhibit B and C that council had appended that wasn't in part the lower court's record to see that, but that's just not what happened here. There was a settlement for $85,000 with Riley. It was spelled out very clearly, like what providers she was claiming bills for, what she was responsible for. The email that was sent to plaintiff's counsel was basically conditions saying you need to get revocations of assignment, basically so they would know that they're not going to be double paying bills that were actually claimed. That would have to happen before there'd be a resolution. There's no response to that email that was attached, so there was not a deal that day. There wasn't a deal until the actual release was signed by both parties. Aside from that, we also filed a motion for reconsideration. Judge Coretti issued a written opinion on that as well. And he basically stated that we did not, we didn't actually answer, or we didn't provide arguments to their reply brief that they'd raised for the first time at a timely manner. So with that, unless there's any questions.
Okay, thank you. No further questions. Thank you for your argument, both of you. That matter will be submitted. That does complete our November 2025 case call session. I want to thank you all for your patience today and great job. And we will get opinions out to you shortly. Thank you.
All rise.